Morning, case 2314, Diaz versus United States. Mr. Fisher.
Mr. Chief Justice, and may it please the Court. The Ninth Circuit holds that Rule 704B prohibits only explicit opinions that the, quote, particular defendant had the state of mind required to convict. The government appears unwilling to endorse that full test. It seems to agree, contrary to Ninth Circuit precedent, that Rule 704B forbids an expert from testifying that people in the defendant's position always have the requisite mens rea. Such testimony never explicitly mentions the defendant, of course, but as the government seems to recognize, it is clearly in the words of Rule 704B, an opinion about whether the defendant had the requisite state of mind. In other words, it establishes a class of individuals, including the defendant, and it assigns a mens rea to that class. Agent Flood's testimony here was no different. He testified that in, quote, most circumstances, people like the defendant know they have drugs in the car when they cross the border. The only difference between that testimony and absolute class-wide testimony is that he posited that people like the defendant usually, instead of always, have the requisite mens rea. But any such distinction is immaterial. Imagine an expert took the stand and said, I believe the defendant in this case probably, or maybe 80% of the time, or maybe there's an 80% likelihood, had the requisite mens rea. Obviously, Rule 704B would prohibit that testimony. And the testimony here is exactly the same. It expresses an opinion, a probabilistic opinion instead of an absolute opinion, but an opinion about whether the defendant had the requisite mens rea. So that leaves the government's final objection that Rule 704B should not be construed to prohibit what the government calls inferentially relevant testimony. And we agree with that proposition. The rule that I'm advocating today has been employed by the Fifth Circuit for over 20 years, and it makes clear that modus operandi evidence, for example, things like drug trafficking organizations use couriers to transport drugs across the border, that drugs are extremely valuable, are perfectly legitimate. The rule in the Fifth Circuit is that testimony from which a jury might infer mens rea is perfectly permissible. But testimony that assigns a mens rea to the defendant or people in her class is not okay. And that's what Agent Flood did here, and for that reason we'd ask the Court to reverse.
Mr. Fisher, you put quite a bit of weight in your argument on the preposition on about. And that was a stylistic change, certainly non-substantive. Do we normally put that much emphasis or that much weight on stylistic changes to statutes?
Well, I think what I would say, Justice Thomas, is the Court obviously puts a lot of weight on the text of the statute. And so I start with the current text of the statute.
Okay, so even with that, it says about defendant. It doesn't say about someone else. So you're saying that even if it's indirect, it's about this defendant.
Let me say two things, Justice Thomas. First, to finish my answer about the word about, what we say is that preposition is important, just like the prior preposition as to before the stylistic amendment, because it makes clear the Ninth Circuit's clear statement rule requiring an explicit opinion is too narrow. So that's what the preposition about does. Now, you also asked me about the defendant, and our position there is very simple, is that that word covers either a direct statement about the particular defendant or a statement about a class of people, including the defendant. I don't think the government disagrees that the rule covers a statement covering, that the rule covers a class of people, including the defendant, as long as it's stated in absolute terms. So if I understand the government's position correctly, it agrees you need not mention the explicit defendant. If you talk about a class of people that includes the defendant and say those people always have the requisite mens rea, I think the government agrees, contrary to the Ninth Circuit, that Rule 704B applies.
Well, I thought the argument there was that if you say all defendants, all people in this class do this, then it obviously would include the defendant.
I think that's exactly right, Justice Thomas. So the only move left from there is to say if the expert were to testify, people like this almost always, virtually always, 99% of the time, probably, in most circumstances, all of those are still opinions about whether the defendant had the mens rea. They're just not absolute opinions. But they're still stating an opinion about whether a class of people, including this defendant, have the requisite mens rea. And I think that's why the text of the rule, opinions about whether the defendant had the mens rea, covers this exact
But I guess I don't understand. Oh, sorry.
I was just going to ask about the defense counsel would, of course, know that this witness is going to testify, right?
Yes.
Could it make appropriate inquiries about the nature of his testimony before? And so after he has testified, he could presumably stand up and ask the expert, Mr. Expert, are you saying that in every case someone knows that the drugs are in the car? He presumably would say no. And are you stating an opinion about whether this individual knew she had drugs in the car? He would have to say no, right? So I don't understand. I mean, obviously, again, you would like a case in which this was a very rare occurrence, but all he's saying is that it's not. It's whatever he wants to say in the majority of cases or whatever, and you can challenge that. And you can particularly make clear that what the concern was about in drafting this rule, you can make clear that he is not telling you anything about this particular individual.
Let me say two things about that, Mr. Chief Justice. First of all, I just want to return to the thing I said in the opening, which is if the expert were to testify that I think there's an 80% chance this particular defendant had the mens rea, the same kind of cross-examination could occur. You would say, Mr. Expert, you're not sure, are you? It's possible he didn't have it. It's only you're saying probably. And I think it would be very hard to argue Rule 704B would not cover that testimony. And
Well,
the reason why...
Go ahead.
Oh, I think the reason why is because what the drafters of the rule cared about was not an absolute versus probabilistic opinion. What they cared about was the expert assigning a mens rea to the defendant or a class of people like the defendant. In other words, it's the subject of mens rea that's off limits, not
I don't know
absolute
that
testimony.
I certainly don't have experience in trials, but I don't know that could he really say there's an 80% chance that this individual had drugs? I think he would have to say more generally that 80% of the people that I've studied or whatever have drugs. I don't know that he can ascribe, maybe he shouldn't be able to ascribe a number to this individual.
Well,
because there may well be situations, and again, the defense counsel can bring them up, why this person would not be like the typical individual that the expert is testifying.
Well, after Rule 704B, of course, the expert couldn't. But I think before Rule 704B, an expert could say, for example, an expert could say, absolutely, as happened in the Hinckley trial, I believe this defendant did not have the capacity to tell right from wrong, so therefore he was insane. And I think Congress would have prohibited that in Rule 704B, just like it would prohibit the expert from saying, I think most likely Mr. Hinckley was insane and couldn't tell right from wrong. And whether you say that in terms of a percentage or just a verbal locution that's probably, usually, most of the time, almost certainly, any of those things would be covered by the rule because they're all an opinion about whether the defendant had that mens rea.
Mr. Fisher, the Ninth Circuit's rule is clear. Your rule, to my mind, is unclear. I still don't understand it. If you don't think that anything from which the jury could infer mens rea is barred by 704, then I don't know where you draw the line.
Well, Justice Alito, I think it might help to understand what you have to decide in this case if I give you a quick preface to that answer.
Well, just give me what the rule should be.
The rule should be that any testimony that the jury would naturally understand as expressing an opinion about the defendant's mens rea is covered by Rule 704.
So that if it's relevant. All right, suppose the expert is asked, how many cases do you have personal familiarity with in which a person drove across the border with a large quantity of drugs hidden in the car? 83 cases. And how many of those cases did the person driving the car know that the drugs were there? 83. Is that barred?
I think that would be barred because it would be equivalent of saying defendants in this position always have the requisite.
Well, it's just a statement of fact about what he has personal knowledge of.
Well, remember, the expert testimony here, and this is at Pet App 13A, was admitted as an expert opinion about whether the defendant had the requisite mens rea. There's an opinion evidence.
All right. Well, this isn't okay. So it would be okay if it's not opinion evidence?
Well, I think it functionally would be opinion evidence, regardless of whether you characterized it. But Justice Alito, I think it might help the conversation if I explained. The Ninth Circuit's rule raises really two questions. One is the expert testimony about mens rea, and is it about the defendant? And we agree with the Fifth Circuit rule that if you if the expert gives testimony that from which the jury can merely draw an inference about mens rea, that's perfectly fine. And there might be borderline cases about what's mens rea, but that's not this case because the expert used the word know. The expert used the word aware.
Well, can
so
I
the only
test
question,
that question about inference? So suppose that the expert gets on the stand and says, in my experience, drug traffickers always inform their carriers before they head out about the nature of the scheme. Would that come under your rule or would it not?
I think it would probably barely fall outside of our rule, Justice Kagan, and but you have identified an edge case. But the reason why it wouldn't fall in...
It's very much like, I sort of expected you to say that because it's very much like the example in your reply brief about tax lawyers being taught something. So this is drug couriers are being informed about the nature of the scheme. So if you say that, I don't really understand what the point of your rule is. Well, I mean, it just suggests that all the expert has to do is, tweak the way he says something, and the exact same testimony can come in.
So let me say the rule and the reason why I gave you the answer I did. Remember, the rule talks about not just any mental state or not facts that might lead to a mental state, but it talks about the mental state of the element of the crime to convict. So here, that mental state is knowing, and that's what the expert expressly said. In your hypothetical, you have to know not just that the defendant was told that, but that she heard it, she understood it, she remembered it, she wasn't told something different.
Now, how about if I say
all kinds of those?
How about if I said something like, in my experience, the organization always informs the courier of the nature of the scheme and doesn't allow the courier to set off until she verbally assents.
Right. I think at some point you get so close that may well be a statement about mens rea. But what I want to emphasize,
I guess what I'm
Justice Kagan,
suggesting, and it's really the same point that Justice Alito was making, I think, is that it just seems at that point a kind of game as to how you frame the testimony so that it falls just over the line, or instead you can argue that it's just inside the line. But in the end, the government is going to get this testimony in.
Well, if you think that's too formalistic, you could, of course, make the rule broader. All I'm saying is that there is a core of Rule 704B, which is statements about the defendant's mens rea, and that's unquestionably what you have in this case. And how far out that goes and whether it covers your hypothetical would just be a different case on different facts. But it has to mean something.
What about your own? Oh, sorry. Why is it a statement about the defendant's mens rea? That's the part that I'm not understanding. So, the chief says if the expert in a situation says 80% of the time, when these conditions exist, the person knows. Why isn't there still an inference to be drawn as to whether or not the defendant is in the 80% or the 20%?
Because the expert would not. The expert is just giving a less than absolute opinion in that regard. It's
no, I
still
understand,
an opinion
but there's
about whether,
right.
And it's still about people in the defendant's class. Let me put it to you this way, Justice Jackson.
No, the question is whether the defendant is in the class. That's what I'm saying. The inference that remains from a testimony that is not 100% is whether or not the defendant is in the class that the expert has identified.
Well, the defendant is certainly in the class, just to use the facts of this case, because the class is people crossing the border with large quantity of drugs in their car. So the defendant is in that class. And our position is simply that the expert is giving a probabilistic opinion as to whether or not she had.
But couldn't you characterize it as the expert is speaking to the class of people who have drugs in their car and know about it?
Well, I think.
And they say, and if you characterize the class as that, then the question is still whether the defendant is in that class, right?
Well, I think. That's one way to put it, but I think, Justice Jackson, imagine the expert testified, I think there's an 80% chance, or I think probably this particular defendant knew she had drugs in the car. That would still leave the same amount of inferential analysis, if you want to put it that way, to be done by the jury, but it's not inference as to mens rea, it's just inference as to whether or not the defendant is guilty or not. It's still a probabilistic opinion, so I think the only thing I want to persuade you of is that just like an expert giving a probabilistic opinion about the defendant herself leaves, if you want to put it this way, some room for the jury to confirm that that expert is correct, that this defendant is one of the majority. The same thing would be true if the expert said the thing about the defendant herself. And the other version of this, I think that helps prove my point, is that I think, again, and I'll let my friend speak for himself, but I think I understand the government to say that if the expert says people like this always know they have drugs in the car, that's covered by Rule 704B. Now, that's contrary to Ninth Circuit precedent, and it doesn't explicitly mention the defendant, but it is covered. And so if you put together the notion that we don't have to explicitly mention the defendant to cover the defendant with the notion that probabilistic opinions are covered just as much as absolute.
Well, I don't know how that, I don't know how that testimony, every single person who drives a car across the border with a large quantity of drugs knows that there are drugs in there, how that gets in under 702. An expert's testimony is admissible under 702 if it is the product of reliable principles and methods. I don't know what reliable principles and methods could lead anybody to conclude that every single person who does that knows what's in the car.
Well,
so there are other rules that take care of the extreme cases. The expert has to satisfy 702, and then there's always 403. If in some case the trial judge thinks this goes too far. I don't know why you have to try to make an exception in 704.
So let me go through both the rules you mentioned, Justice Alito. Under Rule 702, I think the reason why that evidence typically comes in is the expert couches it as in my experience. And to go back to your hypothetical, in my experience, 83 out of 83, therefore people always know. And we cite cases in our brief where the expert has given this exact kind of testimony up to 2013 in the Ninth Circuit.
I mean, the fact testimony, 83 out of 83, is one thing. Whether it's permissible to draw from that experience the inference that they always know, I think that's dubious under 702.
I think you may be right. The NACTL brief talks about some of the problems with law enforcement expert testimony that exists sort of writ large across the courts. And maybe you have a Rule 702 case that you might want to look at sometime when it comes to that problem. But I don't think you need to do that here because Rule 704B is the finer-grained rule that deals particularly with mens rea.
Mr. Fisher, 704 is party agnostic. And so what's going to be good for the goose here is going to be good for the gander. And I would think that would mean that if we're going to allow this testimony, that defendants are going to be able to hire former DEA agents to come in and say, well, there's an 80% chance that drug mules don't know. Is that the world we're going to invite if we find for the government?
It would certainly be allowed, and whether defendants can find those experts is maybe a different question, but certainly...
in my experience, it's not too hard to hire an expert witness.
Well...
So, I mean, but that's what we're going to have. And I'm just wondering how far removed we're going to wind up from what motivated, and if you want to talk about it in that terms, or the text of 704 as adopted, which was to stop, it was motivated in part by the Hinckley case. Right. And we're going to wind up having experts saying there's an 80% chance he didn't know it was the President of the United States. He thought it was a duck.
Or I'm virtually sure and I'm virtually positive in the other direction.
We're going to be right back where we started.
Right. Because what Congress was concerned about was the confusing spectacle of competing opinions on mens rea. And even if, I just add one more thing, even if there were just one expert, if you do want to look at congressional intent, what that intent is clear about is that experts should not be talking about the ultimate issue of mens rea. It's perfectly fine to talk about mental state. It's perfectly fine about experiential facts that lend to inferences about mental state. But the jury's special role in criminal cases is designed to find mental state and experts.
And then just to finish up, the fact that parties can often get inferences through facts about mens rea and therefore come virtually close to this. Is that anything unusual in trial practice? I was always taught there is always a way to skin the evidentiary cat. And I can come up with a whole bunch of facts that suggest that somebody does or doesn't have a mental state.
Yeah, that's exactly right. And of course, the prosecutor at closing can connect all the dots and make an argument to the jury. So I'm not here to make a big dramatic argument, but I am here to make a meaningful argument about testimony that is this explicit about the defendant's mens rea.
Well, that actually, Justice Gorsuch's question brings up one that I had is, what about your client's own expert testimony in this case? An expert who says there's no way for someone to suspect or know that the car has drugs in it.
So I think, Justice Barrett, that particular sentence of our expert's testimony crossed the line of Rule 704B, but remember, the trial judge had already ruled at that point that Agent Flood's testimony was admissible and had construed the rule in the way the Ninth Circuit does to bar only explicit opinions about the defendant herself. So the defendant was playing under the same rules that the prosecution was playing under. We agree on a retrial that particular
that would have to stay out. And what about framework evidence? So the evidence professors say framework evidence is valuable and it comes in most cases. And, you know, your average juror is probably not going to understand how cartels work. So it would be valuable, I would think, to say things like, well, you know, cartels like to know where the car is going to be parked on the other side of the border so they know where to find the drugs. This is the value of the drugs. So this is how cartels do it. So the evidence professors say this would be a terrible rule because framework evidence is valuable. What rule do you see for that?
I think
framework?
the professors just misunderstand our rule, and we're, again, not advocating something out of thin air. It's the Fifth Circuit's own doctrine that we're advocating here, and that doctrine makes clear all the stuff you just posited is perfectly admissible because, again, there's no statement about mens rea in those sentences you just read me. They're just facts in the world that make it highly likely or unlikely a person had a mens rea, but it's not statements about knowledge, to use the mens rea in this case. And this brings me back to Justice Kagan.
Mr. Fisher, sometimes statements about knowledge are actually defense important. You suggested that in this case the defense put that evidence in sort of because they were living in the world that the court had already established. But one of the things the evidence professors talk about is that if you exclude this kind of evidence, you could have a situation in which you have a battered spouse who assaults the person who is beating them, and they're not going to be able to put on expert evidence that negates mens rea in that situation. What do you say about that? It seems to me this is not all net positive for defense.
So I think this is the flip side of the exchange I had with Justice Gorsuch. The defendant in that situation can put on an expert to talk about the phenomenon of battered women syndrome. That expert could testify about the cycle of violence and learned helplessness and the features of battered women syndrome. The only thing the expert could not do is say, I think this defendant or people in her position would not have had the requisite mens rea. But then at closing, the defendant can make that very argument. It's just direct expert testimony about the precise element of the crime that is barred, the mens rea element of the crime that is barred by Rule 704B. So again, I don't have.
But is there a difference between saying the defendant herself didn't have the mens rea or women in this situation didn't have the mens rea? I guess that's what I'm not understanding about your argument.
I think that those two things are both covered by the rule. Now, and even
both
the government.
Covered by, but I thought that's what you just said. They could get up to the line of saying.
They could describe women in the situation of battered women syndrome and what those symptoms are and what those features are of that condition. But the expert could not testify as to whether or not a person with that condition would have had the mens rea to commit this crime. It's just the mens rea testimony. It's not mental state testimony, mental condition testimony more generally.
Mr. Fisher, I want to articulate your rule. And you're right, it's different, but you keep saying it's the Fifth Circuit rule. I'm not sure it's the Fifth Circuit rule, because the Fifth Circuit has criticized evidence with respect to what the drug cartels' knowledge are. So I think you're breaking from the Fifth Circuit as the government breaks from the Ninth Circuit. Everybody's trying to find that happy medium. But the rules of evidence don't say, even if you can get something in a different way, your mistake is you can do it this particular way all the time. I mean, I'm thinking about, we have a lot of hearsay that you can't get it in on the hearsay, but you can get it in for other reasons that don't go to the ultimate guilt of people. Rules are rules, and there's a reason for them. And I think what you're arguing is, this rule says you can talk about modus operandi of drug traffickers generally, but you can't talk about a particular defendant or class of defendants and what their mental state is, because that's what the rule tells you can't do. So it might feel like an exercise without a point, but it is an important point. Isn't that what you're trying to say?
I think that's right. I think we are defending pretty much what happens in the Fifth Circuit. And the reason why that's the rule is because of the importance of mens rea. As the court itself has highlighted in cases in recent years, it is the heart of our criminal law, and it's the heart of a jury's function to make that moralistic, qualitative determination. So if it seems formalistic when I say you're drawing a line, a protective barrier around mens rea, it's because that's what the right of jury trial is about, and that's what the drafters of this rule recognized after
Mr.
the
Fisher,
trial.
has the federal government had any trouble convicting drug traffickers in the Fifth Circuit?
Not to my knowledge, and of course the government's had 20 years to bring this issue up if it didn't like the Fifth Circuit law, so I think it works pretty well in the Fifth Circuit. But let me say something that would lead, if you agreed with the government's concession now, that saying that people in this position always have the requisite mens rea, you're going to have to draw some very difficult lines. What if the expert testified and said, people like this virtually always, 99% of the time? What if the expert said, maybe it's hypothetically possible a defendant, take the 83 out of 83, and the expert said, maybe it's possible somebody could not have known, but I've never seen such a case. Would that count? What if the expert said, like in this case, there's only 3 situations I'm aware of where where the defendant doesn't have the mens rea. And those 3 situations are all different from this case. And then take it one step further in closing argument when defense counsel tried to argue, well, Agent Flood admitted there's a few situations defendants don't have the mens rea. The government objected and said, well, you can't argue that other situations might be possible because he only
those all sound to me like cases in which Rule 403 might well come into play.
Well, remember what the Ninth Circuit says about Rule 403 and Rule 401 is that this testimony goes to the heart of a blind mule defense, like in this case. So it's the exact opposite of being irrelevant or unduly prejudicial.
No, it's relevant, but it has a highly prejudicial value, and maybe it would be excluded by a lot of trial judges.
Well, I think the government's position is in line with the Ninth Circuit, and we concede there's force to it, that this evidence is damaging because it's so directly relevant to the defendant's mens rea. That's the problem with it.
Thank you, counsel. Justice Thomas? Justice Alito, anything further?
Justice Alito is inviting, I think, even more chaos in among courts. If you're going to rely on 403 or 702 or any individualized decision-making by judges, you're just throwing this up into the air with no clarity.
I think that's right, Justice Sotomayor. One way to think about this is you have Rule 403, which is maybe the broadest, most flexible of the rules of evidence to deal with prejudicial evidence. You have the next narrower rule, which is Rule 702, which is just about expert evidence and reliable bases for that evidence. And then you have the narrowest of them all, Rule 704B. I'm only asking you today to apply Rule 704B,
I mean,
which
once you're asking courts to go into asking every police officer, how many of these cases have you had? And when am I going to decide that 10 cases is not adequate, but 83 might be, when there's 550,000 drug arrests? Is 83 enough? I don't know the statistical answer to that. Your rule is much simpler, isn't it?
I think it is.
If you're going to talk about a defendant and what a defendant is thinking, that's off limits. If you're talking about modus operandi of what others do or don't do, that's okay.
Right, so my rule has 2 components. One is it about mens rea? Unquestionably, yes here, because the expert used the word no. And is it about the defendant? And our rule there is very simple as well. Directly about the defendant or a class of people including her. That's the full scope of
And what is permissible, as you said, is if a expert says drug traffickers prefer to hire people that the traffickers know and trust than to hide the drugs in a stranger car, or drug traffickers want to know where the car goes, so they're going to use a GPS or something like that, that's modus operandi.
Descriptive modus operandi evidence that does not speak to mens rea directly is perfectly fine. And Justice Sotomayor, let me add one thing to what you were talking about, because I think it goes back to the Chief Justice's question about cross-examination, and maybe Justice Alito's question about Rule 702 as well. If the expert testified either on direct or cross, look, this is my experience across most cases, but I can't tell you anything about this particular defendant because I don't know anything about this defendant, whether or not she had the mens rea, then you would have a real objection under Relevance or Rule 702. Of course, you had nothing like that in this case. So the plain implication to the jury was not just most people like this have the mens rea, but I believe this defendant has the mens rea.
Justice Kagan?
I feel as though I should offer a bit of my time to Justice Alito to respond to being a chaos inciter.
I'll ask Mr. Guarnieri about that.
What was my question? Here's my question. You've relied quite a number of times on the government's apparent concession that the 100% case would come out your way.
Yep.
I took the government to be hedging on that question. I'll just tell you, we'll find out soon enough. But if the government is not, in fact, taking the position that you took about the 100% case, what changes in your argument? I mean, how much of your argument relies on that supposed concession?
I'm not trying to rely on the concession as such, and I think you're right. There's a little bit of hedge in the brief, fairly, so you can ask him. But I think it is a correct statement of law, regardless of who says it or why, that saying everyone in this position has the mens rea is the equivalent of saying the defendant in the courtroom has the mens rea. It is a class of people that necessarily includes the defendant. So there's really only two things you have to decide in this case, Justice Kagan. That's the first thing, is that when you move from the defendant to a class of people including the defendant, whether you're still within 704B, the answer is yes. And the second question is whether, if that opinion is stated in probabilistic terms instead of absolute terms, you're still within 704B. We say yes. At that point, you're done. And you can leave for another day, modus operandi versus direct statements of mens rea, because you have a direct statement of mens rea here.
Justice Gorsuch?
Just wanted to explore a little bit further your response to the Chief Justice. The 80% he comes in and testifies, 80% no, but admits that he doesn't know about the defendant. How is that evidence in court in the first place?
That's what I was trying to say, Justice Gorsuch. I think that if the expert disclaimed any knowledge whatsoever about this defendant and any inference that might be drawn from his overall experience or from his probabilistic opinion, then I think the defense counsel would rise to object and have a very good ground to exclude that opinion. But that's not what happens here.
Whether it comes out on direct or cross, it wouldn't make any difference.
That's right.
He shouldn't be in court.
The only reason the government is offering this testimony is because the expert is implicitly saying, I believe this defendant probably falls within the group. There's no disclaimer here that the expert is offering, and that's the whole point of the testimony.
So
if I could say one other thing, Justice Gorsuch, that is underscored by Agent Flood's answers on cross-examination, that there's only 3 possibilities that I'm aware of where the defendant does not know they have drugs, and those possibilities are all different from this case.
Right.
So you add that all up, and the expert is effectively saying not just most people, but this person, by logical implication, knew she had drugs.
Correct. And so in this case, the only implication is she knew. In the other cases we've been discussing of 80% and I don't know, then you've got a Daubert problem possibly, and we're going to have to tackle that in the next case.
I think that's right. This is the easier case in that sense, too. It's not just a most case. It's a most, and the only situations I can think of are something else. So therefore, you get to all by the totality of the Agent Flood's testimony.
Whereas down the other road, we're going to have a bunch of Daubert questions. We're also going to have how much probability is enough probability questions, too.
You could. I think the better rule there is that when it comes to Rule 704B, any opinion.
No, I understand your view, but if you should lose, we're going to have Daubert questions and we're going to have probabilistic questions about how much probability is enough.
Exactly. 99%, I'm virtually certain, but I can't guarantee. All these kinds of verbal formulations would be borderline cases.
Justice Kavanaugh?
On the text of the rule, that seems to be a problem for you, just in my view. And then you rely heavily on the government's saying, well, even though the text only says that it prohibits expert testimony that this defendant had knowledge, that may also prohibit testimony that all defendants in the class always have knowledge. And you seize on that, understandably. Mm-hmm. But then the key move in your argument, I think, is that always means the same thing as usually. And that's just not true.
Oh, I agree that's not true. So there's 2 steps, Justice Kavanaugh. So the first is whether the defendant, to use the text of the rule, covers a class of people including the defendant. And I think the answer is yes. And I could just give you a couple more examples. If somebody was trying to figure out what a member of this court thought, and somebody answered, well, Supreme Court justices always think X, that would be a statement about whether that particular justice had a particular state of mind. And then the second step is whether the always versus probably matters. It matters in some sense. It's a degree of certitude. But to go back to the text of the rule, it is still an opinion about whether that justice has something in her mind. So to say if you're trying to figure out what some justice thinks and somebody says, justices usually think X, that is a statement about whether the justice has a particular state of mind. Now, it's not absolute, but it goes to the nature of expert testimony.
How is testifying that usually, how is that an opinion about whether the defendant did have a mental state?
And it's opinion about whether the defendant did or did not have the mental state. So did or did not covers the full scope. Yeah. And I think an opinion can be absolute or it can be probabilistic. Take the example we give in our brief where a therapist, after interviewing a patient, says, people don't usually have trouble getting out of bed unless they're depressed. Well, that's not a direct statement about that individual, but in context, we understand it to be saying, I think you're depressed. You know, we've talked a lot this morning, Justice Kavanaugh, about the nature of expert testimony. Expert testimony is rarely absolute. I think a couple of you have pointed that out today. It's usually a probabilistic opinion. So to go back to the Hinckley case, if the expert had said, I think John Hinckley was probably insane, he probably couldn't tell right from wrong, that wouldn't be an absolute opinion, but it would have to be covered by Rule 704B. And the only thing I'm trying to persuade you of today is to say most people in Hinckley's position wouldn't have known right from wrong is exactly the same statement as saying, I think Hinckley couldn't tell right from wrong.
Thank you.
Justice Barrett?
So I just want to be sure that I understand how we would articulate your rule if you win. So this is, you brought up your depression example. So on page 18 of your brief, in that same paragraph, you talk about the example where, you know, high school seniors generally know the honor code. Mm-hmm. So this kind of is similar to the hypotheticals Justice Kagan was giving you early on. What if I said, so that falls outside of your rule because it refers to knowledge. No, right.
It falls what now?
That would be inadmissible under 704B right. Under your rule, right. Okay, but what if you had somebody testify, and let's just say it was an expert, not a fact witness, that yes, the honor code is distributed to all students, we give them time to read it, they sign it at the bottom, and then we walk out. What about that?
I think that would be okay.
That would be okay, and why? So it's just the word knowledge, is it that formalistic, or once you start stepping back and it takes an inference to get there?
Right, it's an inference, okay. Justice Barrett. In that scenario you're describing, there could still be questions about whether the person who signed the honor code understood the explanation, whether that person remembered the honor code when the alleged transgression happened, et cetera. But you asked me about how you would articulate the rule. If you wanted to be extra careful, you don't even have to articulate that part of the rule. Here you have a statement directly about knowledge. So whatever the line is between knowledge and other statements that might be less direct about the particular mens rea, that would be a different case.
Well, I think we'd be down the sowing chaos road if we didn't
Well, either way, you're going to have to answer that question. At pages 28 to 30 of the government's brief, it says that testimony needs to be understood in context and what it signals in so many words. I think the government agrees that statements are going to have to be understood in context as to whether or not they're about mens rea. So we agree with that. We might calibrate that line a little bit differently, and you could give a first cut at it in this opinion. But again, all you have to say in this opinion, and this goes back to Justice Kavanaugh's question, is that the words "the defendant" cover not just statements about the defendant, but they cover statements about a class of people that includes the defendant, regardless of whether they're absolute or probabilistic. Then you're done. You can say that, therefore we can give some guiding principles to when something is about mens rea or not about mens rea, but you wouldn't even have to do that, strictly speaking, in this case.
Thanks.
Justice Jackson?
So I guess I'm still a little confused about how your rule works. I apologize for that, but Justice Sotomayor suggested that you're saying that expert testimony about modus operandi and actus reus is fine to come in, but expert testimony about mental state is not. So I don't know what happens with battered women's syndrome, which is testimony about the mental state of the defendant. Are you saying that's in or out, and why?
So mental state in general is okay. So an expert can say, I believe this defendant has battered women's syndrome. I believe this defendant, to use the Hinckley example, has schizophrenia. So that's one form of mental state.
I thought that's exactly what the rule says you're not supposed to have an expert do.
No. What the rule says is the mental state required of the element of, as an element of the crime.
Right, and so in the Hinckley case, the element we were talking about was the defense that he was saying, I'm insane.
Right.
And so I thought the rule was that you were not supposed to have dueling experts talking about whether or not he's insane. So I'm positing a situation in which The question is, does this person, are they guilty of assault? And they would like to put on a defense that they had battered women's syndrome, that going to their mental state. In or out?
Some yes, some no, but this is a very important question, so I want to make sure I get it right. So to use the Hinckley example, you could have dueling testimony as to whether or not John Hinckley Jr. had schizophrenia or not. That's not the element of the offense. You could have dueling testimony as to whether or not John Hinckley Jr. had hallucinations or delusions or had difficulty perceiving reality. That's not the element of the crime. The element of the crime is being able to tell right from wrong. That's what you cannot have expert testimony
But it
about.
says element of the crime or defense.
Right, but the defense is still negating the mens rea. So the critical thing is to pinpoint the mens rea. So in the assault case, the mens rea, I think, would be something like a reasonable belief that you're acting in self-defense. I think that's what a typical battered women's syndrome case would look like. An expert can take the stand and say, I believe this person has battered women's syndrome. Here are characteristics of battered women's syndrome. There's a cycle of abuse, there's learned helplessness, there's difficulty leaving. All these things that are not the element of whether or not she believed her life was in danger when she acted.
You disagree with Justice Sotomayor suggesting that all that's off the table because it's mental state evidence. We have to do some sort of
I don't know whether I'm disagreeing with Justice Sotomayor, but at least what I want to say is mental state evidence. Just give another lay example. The defendant, I believe people in this situation are nervous. That would be perfectly fine. It's a mental state, but it's not going to be the element of the crime or a defense. All I'm saying is that Rule 704B keeps out that last step, that assigning the mens rea to the defendant.
Thank you. What about intent to distribute? That is a pretty standard charge.
Yes.
Drugs with intent to distribute. And you have an expert who comes in, and in my experience, this is also pretty standard. The police walk into the apartment. There's all this paraphernalia and chemicals and stuff that a layperson might not understand what this is about. And so the expert that the government puts on the stand says, in my expertise, people who have this kind of material in these quantities in their apartments have it because they're manufacturing drugs that they intend to sell. In or out?
Out because the expert is speaking to intent, which is the mens rea element.
So if they don't put the word intent in, they're manufacturing drugs for sale. In or out?
I think that is a harder case, and so the line would be between saying, scales are used to weigh drugs that, they often get bagged up and sent out for sale. Things about the way that a drug operation might work, things about what those pieces of equipment do or don't do with regard to drugs would be okay. But a direct statement of intent would be not okay. The D.C. Circuit has explained this very clearly, and other courts have held that.
Thank you.
You're right, okay.
Thank you, counsel. Mr. Garnieri?
Mr. Chief Justice, and may it please the Court. By its plain terms, Rule 704B comes into play only when the expert is offering an opinion about the defendant's own mental state. That's the key textual limitation that resolves this case. Agent Flood's testimony did not violate Rule 704B for the simple reason that he did not express any opinion at all about whether Petitioner herself knew about the drugs hidden in her car. Indeed, he did not mention Petitioner a single time in his entire testimony. The Court should reject Petitioner's invitation to replace the line drawn in the text of Rule 704B with one of her own invention. According to Petitioner, Rule 704B prohibits a novel and amorphous category of what she has called class-wide mens rea testimony. That proposal cannot be squared with the text, purpose, or history of the rule. And I think the history is particularly instructive here. I want to emphasize 3 points this morning. First, when Congress enacted Rule 704B in response to the acquittal of John Hinckley, Congress adopted a reform that applies equally to both sides. It is party agnostic, as Justice Gorsuch observed this morning. It is not a rule targeted at government experts, and whatever the Court says in this case will also govern future expert testimony offered by the defense on issues like insanity or battered women syndrome. Second, Congress kept Rule 704A in place. The general rule in federal court continues to be that opinion testimony is not objectionable merely because it embraces an ultimate issue. Rule 704B operates as a limited exception to that general rule. And third, the original text of Rule 704B confirms that an expert may still testify with respect to the mental state or condition of the defendant, as long as the expert stops short of opining on the ultimate issue. Agent Flood respected that limitation here. I welcome the Court's questions.
But Mr. Fisher makes the point that, in effect, when you talk about the probabilities of someone carrying drugs, that you are, in effect, talking about the defendant, that you could only be concerned about the conduct of the defendant. So how would you respond to that?
Well, I think my friend on the other side is conflating two distinct issues in this case. One is whether the expert is offering an opinion that is about the defendant herself. Agent Flood did not do that here when he testified in general terms that drug traffickers do not entrust large quantities of drugs to people who are unaware of those.
Well, his point is that it wouldn't be relevant otherwise if you weren't talking about the defendant.
Well, I think that's right, Justice Thomas. It's true that it is relevant because we are asking the jury to infer something about the defendant herself, about Petitioner herself, from the expert's opinion. But that doesn't make it an opinion. It doesn't mean the expert is expressing an opinion about the defendant. When Rule 704B talks about expressing an opinion about the defendant, it means expressing an opinion framed in terms of the defendant's own mental state.
So if I understand it right, for relevance purposes, it has to be about the defendant, right?
Yes, I think that's what makes the testimony relevant.
That's the only way in which you get this evidence in the first place. It has to be about the defendant. We're not talking about some stranger to the suit, right?
Yes, I
So it's
agree.
about the defendant for purposes of 702, but it's not about the defendant for purposes of 704. Help me with that.
It is relevant to the defendant. Let me give you a plain language example.
Is it with respect to the defendant?
If I told you, Justice Gorsuch, that I had just read a terrific book about Julius Caesar, I think you would expect that the book at least mentions Julius Caesar somewhere in there.
No.
And if you learn that it's a book about ancient Romans...
No, I wouldn't necessarily. Yeah, it can be about his times and his place and the Roman Empire of the era.
I think that's exactly right, and that's my point, Justice
Okay,
Gorsuch.
and I'm drawing an inference about
understand.
him.
That's right. That's exactly right, and that's how we think the rules
You
operate
want us to
here.
you want the jury to draw an inference about the mental state of this defendant, don't you?
Yes, we are offering the testimony because it is relevant to the jury's assessment of Petitioner's own mental state. But that doesn't mean that it is an opinion about the defendant's mental state. If you accept the logic of that argument, a great deal of testimony that
I would
is
think that a great
inferentially
many
relevant.
district courts would, on that theory, say that this testimony should be stricken on 702 grounds. It's just not relevant.
704.
Is that what you're inviting?
No, we are not inviting that, Justice.
No, of course not,
Indeed,
right?
The district court in this case, Petitioner made a Rule 401 objection to the relevancy of this testimony. The district court overruled it. Petitioner has not renewed that contention in this court. I think there is testimony that is relevant to the jury's assessment of the defendant's mental state that is nonetheless not testimony that is opining directly on the defendant's.
Nor could the defendant, nor could the expert actually opine because he's not an examining expert. Isn't that right? I mean, there really isn't a world in which this expert could speak directly in a sense to what is going on in this defendant's mind. The only thing he is competent to testify about is sort of in his expertise how these things work as a general matter, right?
I think that's correct, Justice Jackson, and indeed in this particular case, Agent Flood confirmed that he was not involved in the investigation of this case when he was asked that on cross-examination.
Mr. Guarnier, do you want to first answer the 100% case?
Sure. So I think Petitioner is misreading our brief on that point. I mean, we think that the distinction between testifying in absolute terms or conditional terms about the way that drug traffickers operate is really more of a reliability issue. I don't think at this point in time we could sponsor an
So in
testimony.
fact, your argument would be the same if the expert got up and said, in my experience, 100% of the time, drug traffickers use couriers who know that there are drugs in the car.
Yeah, I think we would have the same Rule 704B position with respect to that testimony. And the key
So
to the application of
all
Rule 704B...
defendants know that they of drugs, And you're still not testimony about the defendant's mental state.
Well, Justice Gorsuch, I want to be careful and precise here. If the expert testifies that all defendants know, or that all drug traffickers and this defendant, or this defendant and other drug
all mules, to use the common parlance, all mules know that the drugs are drugs in their car.
Yeah, I don't
that's still permissible under your view. It's not about the defendant.
It is not objectionable on Rule 704B grounds.
Still not about the defendant.
Testimony would necessarily
the defendant just happens to be there. It just happens to be a trial in which that person's in jeopardy. But we've got this testimony over here, and it doesn't matter.
Yeah, I don't
Justice
understand that, right?
Gorsuch,
Because isn't this like necessarily saying 100% of defendants know? Aren't you necessarily saying this defendant knows? Isn't that what Justice Gorsuch is?
I think the distinction
Apparently
between those
not.
two.
Isn't the answer, Mr. Guarnieri, that...
But what is the answer, Mr. Guarnieri?
Thank you, Justice Kagan. Look, I think the distinction between those two, the key point that we're trying to get across is that Rule 704B forbids a particular form of opinion testimony. The expert cannot opine on the defendant's own mental state. And so we acknowledge in our brief that there are going to be circumstances in which experts testify about a class of people and put the defendant in that class. That form of expert testimony could be objectionable. But if the issue is just that the defendant is describing a general category of persons,
how about this?
And they want to make a categorical statement about that group of people, I don't think that's a 704B problem.
How about this? In my experience, I've seen a lot of cases, and I'll tell you that a hypothetical person with this many kilograms of drugs in its car, caught in this kind of way, in a car with this make and model, who says the following things to the police when she's caught. In my experience, a person like that is always going to have known about the drugs in her car.
Yeah, I think that would be objectionable. Of course, that's not the testimony we had in this case, but the D.C. Circuit has a case which we cite in our brief addressing that kind of use of mirroring hypotheticals. I think that's just a transparent way to circumvent Rule 704B. That's not this
Okay,
case.
so then I'm not really understanding, because if you say, look, you don't have to say Ms. Diaz knows, as long as everybody understands that the description you're giving of the person who knows mirrors who Ms. Diaz is. So you're not willing to be as formalistic as to say she has to be named. You're willing to say the same rule should apply if there's a description that basically matches her. Well, then I don't get why you're not willing to say if the description is a class in which everybody agrees she's a part and it's 100% of the class.
Well, Justice Kagan, the way we would articulate the rule is the same way that the Ninth Circuit has articulated and the Second and D.C. Circuits and other courts of appeals have articulated, and that is that what the expert may not do is testify in such a way that necessarily compels the inference that the defendant had the requisite
But it's just a matter of degree as to whether the class is really super narrowly about one person, or then gets a little bit broader, or then gets a little bit broader. But in all these cases, the person is a member of the class, however exactly you define the class. So I guess I don't see why at some point you're willing to draw the line.
Well, I'm not sure that's true, Justice Kagan. There are going to be cases in which there's a dispute, a factual dispute, about whether or not the defendant is in the class. Does the defendant have this mental condition or defect, or this other one, or perhaps no mental disease or defect at all? So the parties can join issue on whether the defendant is even in the class that the expert is describing. To step back here, I also want to again stress that Rule 704B is a limited exception to the general rule here, which is 704A. And that is that, in general, opinion testimony is not objectionable just because it embraces an ultimate issue. You can have, when Congress enacted Rule 704A, it made a judgment that we're going to, in general, abolish the ultimate issue rule in federal court. And really, these disputes should be channeled through disputes about the reliability of the expert's testimony, whether the expert's testimony is based on sufficient facts and data under Rule 702. You can have robust Daubert gatekeeping under this court's case law, which is now reflected in the text of Rule 702. And Rule 704B is just a limited prohibition on a specific form of expert opinion testimony in criminal trials. Agent Flood's testimony looks nothing like the testimony that Congress forbid when it enacted 704B. The other point that I would make this morning, And this, I think, goes to some of the concerns about how you engage in the line drawing that both parties' positions might present. I take my friend on the other side, his move this morning in response to a number of the more difficult questions the court posed was to say that, well, testimony that is would provide a basis for the jury to infer the defendant's mental state is not actually about the defendant's mental state unless it is framed explicitly in terms of knowledge. So, for example, the tax lawyer example that we offer in our hypothetical, I take my friend on the other side to agree that testimony that tax lawyers are generally instructed in the requirement to pay some particular tax is not opinion testimony about that would be forbidden by 704B because it doesn't speak to knowledge. And I think that's actually the correct understanding of about. It's not about mental state if it's not framed directly or expressly in terms of mental state. But the problem is my friend on the other side doesn't logically carry that through to the rest of the text of Rule 704B. The opinion has to be not just about mental state, but also about the defendant's own mental state. And to be about the defendant's own mental state, the expert has to be, in general, explicitly taking the stand and expressing an opinion for the jury about what was in the defendant's mind.
Functionally equivalent. Now what we're arguing about, because you've just conceded earlier that if you do, we can argue about how wide you define the class, but you could just say anyone who has 55 pounds of drugs in their car, hidden or not, knows the drugs are there, period. To me, that's a functional equivalent of saying this defendant had 55 pounds of drugs, so she has to know. And you admitted to Justice Kagan that there is a point at which you reach that functional equivalency.
Yeah, I wouldn't really describe that, though, as a dispute about how you define the class. I mean, I think in general...
No, the dispute is about, are you saying it's this defendant?
I think in general the rule here is that the expert may not express an opinion that leaves for the jury no room to make the ultimate inference for itself. And if you express an explicit opinion about the defendant's state of mind, that could be sufficient for a violation. All we're saying is we want to leave open the possibility that that might not be necessary for a violation, because you're going to have these extreme cases in which an expert contrives to offer some opinion that carefully avoids stating an express opinion about the defendant in that particular case, but nonetheless logically necessarily compels the inference that the defendant had the requisite mental state. So we're talking here about the marginal case. And again, to return to some of the...
Can I just ask you before you go on, I'm wondering whether some of the problem here might be our not really focusing in on the fact that there are different kinds of experts and different kinds of testimony. And so to the extent that this rule says that it relates to an opinion about whether the defendant did or did not have a mental state or condition, and it was generated in the context of a dispute about testimony related to the psychiatric or physical condition of a particular defendant, Hinckley, I'm just wondering whether the problem might be that this is really directed at not this kind of testimony, the kind of testimony that comes from an expert who hasn't examined this defendant, doesn't know anything about this defendant, and is talking about framework or, general modus operandi, whereas this rule seems to be targeting the kind of expert who has examined or knows something about this defendant's mental state. What do you think about that?
Well, Justice Axson, I think that's correct as a historical description of what Congress had in mind here when it enacted Rule 704B, but I think the logic of that intuition supports our position in this case, not petitioners. And that is because when Congress enacted Rule 704B against the backdrop of robust public debate about what appropriate testimony, what appropriate expert testimony should be offered in criminal trials involving the insanity defense, it was clear to everyone at the time that Congress was not eliminating all expert testimony in insanity trials.
No, of course not.
The text of the rule...
I mean, isn't the line, I thought in the text, had to do with whether it's an element of the offense or the defense. So, for example, in Hinckley, an expert could still get up and say and opine on Mr. Hinckley's mental state to the extent he has schizophrenia. You can say that. And a battered woman, she has what we would define as battered women's syndrome. What they can't do is say, and therefore Mr. Hinckley or or any other defendant did or did not have the mental state required to either convict or to make out an insanity defense. That's the line, isn't it?
Yes, Justice Gorsuch, and I think that is just an articulation of our position in this case. And to return to our earlier exchange, and I think this again goes to Justice Jackson's question as well.
And so if that's the case,
everyone understands
if that's the case, counsel, what's the difference between saying Mr. Hinckley didn't understand right from wrong, A, B, a hypothetical person who looks just exactly like Mr. Hinckley couldn't have understood right from wrong, and C, all persons with the characteristics of Mr. Hinckley do not understand right from wrong. What is the difference between those three statements?
If I've understood the examples that you have offered, Justice Gorsuch, those are all just variations on the expert taking the stand and saying that the defendant, in fact, met the legal standard. And again,
so they're all impermissible.
I think those all could be impermissible if I've understood the three examples. But Justice Gorsuch, again, earlier, I think one of our exchanges was about, well, isn't it only the fact that it is coming into court at all shows that it's being offered to prove the defendant's mental state? And I think the Hinckley example shows that can't be the correct understanding of Rule 704B. Everyone understands when you're calling your examining expert in a trial involving the insanity defense to offer that expert's diagnosis of the particular defendant's mental state. The reason it is relevant is because you want the jury to draw some inference about whether the defendant does or does not meet the insanity defense, the legal standard for insanity. That doesn't mean it's prohibited on 704B grounds.
If we think about the insanity argument, I mean, an expert can come up to the stand and say, a person with these sorts of behaviors or sorts of symptoms, I would say that that person has schizophrenia. That's fine, right?
Yes.
Okay. And then could the person then say, I think that all people with schizophrenia have the necessary capacity to form an intent as to this crime?
I don't think that would be objectionable on 704B grounds.
Okay.
I doubt it would be reliable, but it wouldn't be objectionable on 704B grounds. And
because that, to me, is what the Hinckley controversy was about and why Congress passed this rule. That it didn't want the expert to go from the step of saying, looks to me like this person has schizophrenia, to the conclusion that, okay, once we say that, we can say that this person has the necessary intent because all people with schizophrenia can have the necessary intent, or not.
Yeah, I think the problem with the particular testimony that Congress was targeting in Rule 704B is that the expert is drawing an explicit link between the defendant and the legal requirement that the jury has to find. That's what Congress said, no more of that.
Well, that is what the expert in my hypothetical is doing, because he's saying this defendant has a certain kind of disease, and I'm going to tell you what people with this disease, whether they're capable of distinguishing right from wrong, or whether they're capable of having some other necessary intent for the crime. So he's saying, as a fact of the matter, in his professional opinion, but 100% of the people with this disease are going to have this intent.
Yeah, well, Justice Kagan, I think you have just that's a variation on the syllogism that we identify in our brief at pages 28 to 29. If the expert says, everyone in this category, if you are in category X, it follows that you have mental condition Y, and also I, as an expert, have diagnosed the defendant as being in category X, you have just broken down one impermissible opinion into two steps, and we do think 704B would keep that out.
Well,
but again, it's not the categorical nature of the testimony that is the problem here. If you have a case in which you have called an expert to describe, for example, color blindness, and that's relevant to an ultimate issue in the case, and the expert wants to come into court and say, everyone who has color blindness, this is what follows from that. The expert doesn't need to qualify that testimony in order to circumvent Rule 704B.
Mr. Guarnieri, you're making this a lot more complicated than I think it has to be. 704B says about whether the defendant did or did not have a mental state or condition, It doesn't say is relevant to. The Rules Committee presumably knew what the standard was for relevance, and if they wanted to say that the expert cannot state an opinion, cannot state anything that is relevant to the issue, they would have said so They would have said so explicitly. And a lot of these hypotheticals, it seems to me, are taken care of by other rules. I don't know how any expert could say 100% of the time this is true. I don't think that's reliable. It's subject to objection under 702. And some of these matters could be handled under 403. I don't know why you're, and then some of them could just be fuel for devastating cross-examination. If an expert says 100% of the time this is true, I think that that would be that might well harm the case of the party who introduces that testimony. But let me ask you this. There are people who think that there's a lot of chaos in the states that comprise the Ninth Circuit, but I don't know, until this morning, it hadn't occurred to me that maybe the cause for this chaos is the Ninth Circuit's rule about 704. Do you think that's true?
No, we have not seen any practical problems in applying the longstanding understanding of Rule 704B that we are advocating in this case. And Justice Alito, to your earlier points, I entirely agree with you that many other rules would take care of some of the hypotheticals that we are battering about today. I took the court to just be interested in how do you define the outer limits of how Rule 704B should apply. Of course, this case doesn't necessarily present any occasion to address those outer limits because Agent Flood's testimony here looked nothing like some of the hypotheticals that we've been discussing this morning. The other point I would make, Justice Alito, and we advert to this in our brief, Rule 702 itself was recently amended in ways that were meant to discourage experts from overstating the certainty with which they could express their opinions on the stand. Rule 702 and Daubert gatekeeping is really the way that you handle concerns that an expert is stating something in categorical or absolute terms that is just not supportable by the facts underlying the expert's opinion.
Counsel, have you had any trouble convicting drug mules in the Fifth Circuit?
No, Justice Gorsuch, and I take your point that this isn't going to be critical testimony in every case or indeed in any particular case, and we have instances
in this case, for example, the defendant couldn't roll down her window, and the border agent well knows that usually means there are drugs stuffed inside the panels of the vehicle, right? I mean, one can draw an inference from that pretty quickly when she says, I can't roll down my window. I mean, there's... In my experience, in the 10th Circuit, for example, we took as a reliable indication sometimes one contributing factor for a traffic stop was there are air fresheners in the car, okay? And it was traveling below the speed limit, okay, and in a panel van, and the windows couldn't roll down. I mean, all the modus operandi evidence in the world, and you can draw inferences from that. The one thing the rule says is you can't reach inside someone's head, and it doesn't seem to be a problem in the Fifth Circuit.
Justice Gorsuch, I don't dispute that. I think you're right. We are convicting defendants of illegally importing drugs into the United States in the Fifth Circuit without this testimony. And so, too, I think we could obtain convictions in the Ninth Circuit without this testimony. And we have a harmless error argument here, which, the upshot of that argument is I think the other evidence in this case was overwhelming that Petitioner knew about the drugs in her car. Nonetheless, this is helpful and reliable testimony, and we think the jury should be allowed to hear it. And I think if you're thinking about the case through the lens of, what is sort of the practicalities here, if you adopt Petitioner's rule, on the other hand, it's going to open up a host of arbitrary and difficult line-drawing exercises that I don't think he really had persuasive answers to this morning. And so I think that what the court should do is stick to the text of Rule 704B itself, and Rule 704B only comes into play when the defendant expresses an opinion about the defendant's own, when the expert expresses an opinion about the defendant's own mental state, and Agent Flood didn't do that here. He said in most circumstances, drug traffickers do not entrust large quantities of drugs to people who are unaware of those drugs. He explained why that was true, and he elaborated on cross-examination that, of course, he is aware of some scenarios in which the traffickers may try to use so-called blind mules, and he described the facts of those scenarios, and they don't meet the facts of this case. Everything that occurred here occurred in full compliance with Rule 704B, and we would ask the court to affirm.
Thank you, counsel. Justice Thomas? Justice Alito?
On the question of whether you've had difficulty convicting mules in the Fifth Circuit, It reminds me of Rule 10,000 of the rules of the Federal Rules of Evidence, which used to be applied by district judges to exclude evidence that prosecutors wanted to admit, which was the "you don't need it" rule. So, if you don't need it, and there's a conceivable possibility, there's a possibility that it might create an issue on appeal, the judge would keep it out. Do you think we ought to create that rule, make that an enforceable judge-made addition to the Federal Rules of Evidence?
No, the federal government opposes that rule, Justice Alito. There's a metaphor in the advisory committee notes to Rule 401. I think it's from Professor McCormick, and he said, as to relevancy, that a brick is not a wall. And what he meant was you have to build your case up brick by brick. Every brick is not itself going to be dispositive of the whole case, but they're helpful, and we are entitled to present reliable and helpful evidence of petitioner's guilt and of guilt generally in cases like this. I think this is just, the question shouldn't be, do we need it? Is it prohibited by the federal rules or the Constitution? And this testimony is not.
Justice Sotomayor?
So you have not backed off of your answer to Justice Gorsuch or to Justice Kagan that if 100% inference is pointing to the defendant, that's a functional equivalency, and you would agree that that should be excluded, but you say it should be excluded under a different rule, perhaps. But you didn't even go that far. You said under 704 that might cross the line. Well, to say that every defendant with schizophrenia doesn't know right from wrong, or knows right from wrong, because some expert could say schizophrenia doesn't cloud your mind, it just makes you believe you have a reason to do it. So which is it?
Well, Justice Sotomayor, 2 points. One, to the extent that I've muddled things this morning, I regret it. But the key thing from our point of view about the application of Rule 704B is whether the testimony is framed in terms of the defendant. And I think my friend on the other...
It has to be this defendant, correct?
Well, I think the key question from our perspective in confronting a hypothetical like that would be, has the testifying expert himself taken the stand and put the defendant in that class? If all that is at issue is that the jury could infer from other evidence, in order to put petitioner in the class of drug courier...
So how about if he says 99.9%?
Yeah,
no.
Again...
95% no? 90% no? Where do we draw the line?
Yeah, I don't think that's the line that Rule 704B draws. It's not a rule about categorical versus conditional testimony. It's a line about expert opinion testimony about the defendant.
About
the distinction
about a defendant's mental state.
Yes, and I think if you have concerns in a particular case that a defendant's opinion, that an expert opinion is, overstating the certainty with which that expert could describe some fact of the world, that's a problem under Rule 702 and Daubert. It's not a problem under Rule 704B.
Justice Kagan?
Mr. Fisher might have some line-drawing problems, but I think you do too, Mr. Guarnieri. If I understand what you're now saying, on the one hand, and if an expert got up and said 100% of drug mules know what they're doing, that could not be excluded under your rule. But if the expert got up and said, I think that this defendant, it looks like from the packaging, she was working for this particular drug cartel. And now I'm going to tell you that 100% of mules who work for this particular drug cartel know that they're carrying drugs. Then you say it is excluded. Is that correct?
Yeah, I think that is the expert expressing an opinion for the jury about the defendant having the requisite mental state. That's out under 704B.
Okay, and so then if we go back to the one that is not excluded, it's the expert getting up and just saying all drug mules have knowledge of what they're doing. I guess I'm just not seeing the difference between that statement and the other one, because everybody knows that this woman was caught in a car with drugs. So she's a drug mule, and the expert is saying all drug mules have knowledge. So once you're going to tell me that the other is excluded, that should be excluded too.
Well, Justice Kagan, let me try and answer that question on two levels. One,
Well,
just
I
a
just
mechanical
wanted
level.
on my level.
Well, I think
like
think
the
this-
level of the question.
Justice Kagan, the distinction between those two is the distinction drawn in the text of Rule 704B itself, which is the expert expressing an opinion about the defendant? And in one, the expert is expressing an opinion, taking the stand, and testifying to the jury, I, as an expert, have concluded, as a matter of my expert opinion, that the defendant had the mental state, the requisite mental state. Rule 704B forbids that. Now, the second level response that I also wanted to offer to your question, Justice Kagan, is
But I don't really understand.
there's a rationality, there's a reason that Congress drew the line that it drew in Rule 704B, and it has to do with the Hinckley trial and the concerns that there's a kind of expert opinion testimony that is particularly problematic that Congress wanted to keep out, and that's
Okay,
it.
thank you.
Justice Gorsuch?
I am thoroughly confused. So a hypothetical saying someone in John Hinckley's situation who looks just like John Hinckley but isn't John Hinckley couldn't have had the requisite mental state. That's out.
Well, again, it's not this case.
Is that out or in? Just out or in?
I mean, the so-called mirroring hypotheticals,
Yes.
I think, are out
All
for
right,
a proper
okay, all right,
understanding of Rule
okay.
704B. We accept that.
Now I have the expert who says in the John Hinckley case, or the mule case, you just flip it around, all people with schizophrenia cannot form or can form the requisite intent, or all mules can do or do not know, in or out.
I don't think that testimony like that would be objectionable on 704.
So that's all in. I'm sorry, I'd understood you in prior questions to say that was out.
Well,
Did I misunderstand you, or have you spoken both ways today?
I do not think I've spoken both ways. The line I've tried to draw here, and it's the line that our brief articulates, is the expert opining about the defendant herself.
Now, why would Congress draft a rule saying experts can't opine about the defendant's mental state after the Hinckley trial and forbid a district judge from admitting evidence about a mirroring hypothetical that looks just like John Hinckley, but still allow in an expert to say nobody in the class in which John Hinckley falls has the requisite mental state? What rational Congress would do such a thing?
I think Rule 704B, if you look at the history of the provision, reflects a judgment by Congress that having dueling experts in insanity cases directly opine for the jury on whether the defendant satisfies the legal definition of insanity was unseemly, that it created a public spectacle that undermined the integrity of the proceedings.
But you're allowing
and
in
that it
all
led
of
to
that
overstatement
testimony.
by the experts.
You're still allowing in all of that testimony.
Well, I think, again, and this...
All he has to say is instead of Hinckley or instead of a mirroring hypothetical, all persons in this category.
This goes back to an exchange that I had with Justice Jackson earlier. I think it was the understanding of everyone involved at the time, and the text of the original rule reflects that you are still going to have experts who can come in a criminal trial and testify with respect to the mental state or condition of the defendant.
Certainly.
That's not
with respect
prohibited
to
by
whether
Rule
he
704B.
whether he has schizophrenia. Sure, whether he has a mental illness, yes, but not, I mean, the text of the rule says not with respect to the element of the crime or the defense.
That's right.
Okay, thank you.
Justice Kavanaugh?
On the text, if we stick to the text, that should be our key, right?
I think we win this case under the text, Justice Kavanaugh.
Right. And are the hypotheticals you've been getting real-world hypotheticals?
No, I don't think so, although I will acknowledge that in the Ninth Circuit there was a time when we did elicit testimony that no drug trafficking organizations used blind mules because that's what we honestly believed at the time. And that testimony, we don't sponsor testimony like that anymore because it's not true.
And it's not true, and if someone tried to introduce testimony like that, I think, and Justice Alito said this, other rules take care of that in terms of reliability, et cetera.
Yes.
Thank you.
Justice Barrett? Justice Jackson?
I guess that drawing a line between testimony about a class or group on the one hand and testimony about an individual happens at trial all the time. Judges are familiar with drawing that line, and I'm interested in the law professors, evidence professors' brief because they point to one context in which that happens with fair frequency, which is with respect to eyewitness testimony. And they say courts often allow expert testimony regarding factors that, on average, interfere with accurate eyewitness identifications. However, courts do not allow experts to draw an individual inference and testify that a particular witness is likely inaccurate. They go on to say because social science research isn't reliably, even though it is itself replicated and reliable, it can't support a reliable statement about an individual case, especially when that social scientist hasn't really examined that individual case. And so judges, they at least say, are pretty familiar with the kind of line. So is this the line you're drawing?
Yeah, well, Justice Jackson, I think that brief, the point the professors are making in that brief is that concerns that the expert has testified in some way that overstates the expert's ability to draw an inference about the particular case are not unfamiliar in federal court. Courts handle those kinds of concerns every day under Rule 702, and you could have a similar dynamic for testimony like this.
Right, and that, I guess what I'm suggesting is that there is a difference between an expert talking about a group and on average, and here are the statistics that relate to how people operate or think or whatever as a group, and that's actually a different kind of testimony and ultimate goal and helpful thing for jurors when they're trying to draw the inference as to whether or not this individual, right, is a member of that group, meaning acted in the same way or thought in the same way. That's still left to the jury so long as the expert doesn't himself go on to say, and this individual is in that group, right?
Yeah, I think that's exactly right. We think that's how Rule 704B should work, and here Agent Flood certainly left a great deal for the jury, a great number of the links in the chain of inferences for the jury itself to draw.
Thank you.
Thank you, counsel. Rebuttal, Mr. Fisher?
Thank you. I'd like to start by just making absolutely clear for the court that the government is not defending the Ninth Circuit's case law on this Rule 704B. So on the mirroring situation the court has talked about, there's a Ninth Circuit case from 2005 called Younger, where the Ninth Circuit says that evidence is admissible because it does not particularly speak to the defendant, with the defendant in italics in that opinion. So the government there is moving away from the Ninth Circuit's view. I don't fully understand exactly what the government is saying about what we've called 100% testimony or always testimony, but Justice Kavanaugh, I do want to absolutely stress those are real-world examples. They're at page 23 of our brief. That's the exact testimony that agents like Agent Flood gave in cases like this until 2013 when the government discovered there actually were some blind mules out there. So it's merely a situation of this particular scenario where the government's backed off it for empirical reasons. But you could have other cases where an expert would testify in the real world that people with schizophrenia can never tell right from wrong, that executives and corporations, when they lie to government investigators, always know they're telling a lie. That would be perfectly real-world examples. And I think regardless of what the government's precise position is, it's very difficult to argue that kind of testimony would be okay under Rule 704B. Let me give you one last scenario about the government's line-drawing problems. There's a case called Watson from the Third Circuit that's in our brief. The government itself seems to agree with the outcome in Watson. In that case, the prosecutor asked the expert, do you have an opinion as to whether or not the defendant here had the requisite intent? The expert says, yes, I have an opinion. People like this generally have the requisite intent. The government seems to agree that is out under Rule 704B. Now, maybe that's because at pages 28 to 30, it draws a contextual rule of some kind, but there are these very difficult line-drawing problems under the government's rule. Our rule is simple. If you talk about the defendant herself, it's covered by Rule 704B, or a class of people, including the defendant. You're covered by Rule 704B. Here, the class of people, Agent Flood is quite specific, people carrying large quantities of drugs across the border. That's the class. The defendant here is unquestionably a member of that class, and so his testimony is about the defendant. I want to say one last thing. Justice Kagan and Justice Jackson asked about some of the history and intent of Rule 704B. Let's just use the Hinckley case. In the Senate report, it's only a page long. I would urge you to read that if you think that's important here. And what the Senate said was, we're concerned about experts testifying about the subject of mens rea, And so after the Hinckley trial, if an expert were to testify, we think people like this or exhibiting these conditions generally couldn't tell right from wrong, or probably couldn't tell right from wrong, or in most circumstances couldn't tell right from wrong, it seems crazy to think Congress would have thought that was okay under the Hinckley trial. The problem in the Hinckley trial was that the expert was testifying not just about facts from which a jury could infer mens rea, but the jury was expressing an opinion on the ultimate issue of mens rea. From which the jury could go into the jury room and do nothing but say, we agree with the expert. And whether the expert expressed that opinion in terms of probably this defendant had the mens rea or didn't have the mens rea, or certainly, the problem is that the jury can go back to the jury room and say, look, sounds like Agent Flood, thinks people like this generally have the mens rea. He must be right. We'll go along with that. The point of the right to jury trial and the point of the ultimate issue doctrine is that when it comes to the special subject of mens rea, and Justice Jackson, I want to be really specific here, mens rea as the element of the crime to convict or as the defense, that particular subject has a wall around it. The jury is required to make an independent, moralistic, qualitative determination. And that's what Agent Flood did wrong here. He said, most people like this know they have drugs in a car. Knowledge is the exact element of the crime. So whatever else Rule 704B may cover in terms of statements that cover mens rea, this one explicitly did, and that's why it went over the line.
Thank you, counsel. The case is submitted. Argument next in case 22-1079, Truck Insurance Exchange versus Kaiser Gypsum Company. Ms. Ho.
Thank you, Mr. Chief Justice, and may it please the court. If anyone is a party in interest entitled to be heard in this Chapter 11 case, it's the insurer, Truck, who will pay virtually every dollar the debtors owe the asbestos claimants. Yet the Fourth Circuit's rule denies that insurer a voice. That rule, which my friends barely defend, violates the text, context, and history of 1109B. It also defies the practical reality that Chapter 11 cases are, as this court has recognized, collaborative, working best when all stakeholders come together at the outset to hash things out. Congress recognized that reality and spoke expansively in 1109B to extend the right to be heard to any issue. Congress also gave courts a duty to ensure compliance with the code and invited broad participation to help discharge that duty. 1109B's breadth is a feature, not a bug. It's now common ground that a party in interest is one who could be directly and adversely affected by the case. That's Truck in at least two ways. First, it's the insurer, paying the vast bulk of claims against the debtors. In the government's terms, it's a contracting party. From the start, then, Truck's rights could have been directly and adversely affected by this case. The proof of that pudding is in the plan finding, which resolved a key coverage dispute against Truck. Second, Truck's a creditor for millions in insurance deductibles. For both reasons, 1109B's plain terms entitle Truck to be heard on any issue. In silencing Truck, the Fourth Circuit violated those terms by limiting who a party in interest is and what issues they can raise. I welcome the court's questions.
Ms. Ho, at what point do you determine the status of party in interest?
Thank you, Justice Thomas. At the outset, Section 1109B's text refers to be heard under any issue in this case. So we think that has to be an ex ante inquiry, in part because there are other provisions of the code apart from 1109B that affect parties in interest that don't depend on a specific plan or any plan.
Well, in this case, the determination at the end was that truck was not negatively affected. How could you determine that at the beginning of the proceedings?
Yes, Your Honor, because I think the question should be, could the entity be affected by the Chapter 11 case? And as the insurer, there are any number of ways that truck could have been affected. It could have been affected by a plan that resulted in the one as we were seeking with fraud prevention measures, or it could have resulted, as had happened, in a plan that didn't include those. We came into this Chapter 11 proceeding as a creditor. The proceeding could have resulted in our claims being impaired or unimpaired, and you don't know that until the end, but that doesn't, the language of 1109B speaks to a creditor. So if you're a party in interest in the beginning with a right to be heard under 1109B, then you're a party in interest all the way through.
What if, I know could have some back and forth about the facts, but in a hypothetical, let's assume that your client, whichever plan, there's 3 different plans on the table, and under every one, your client gets, his exposure is exactly the same. It makes no difference to him which particular creditors are going to get what. He's just, given the factual situation, he's going to walk away with exactly what he has or what he doesn't have when it's all done. In what sense does he have an interest in how his assets are distributed or what the liabilities are? In other words, although he is, you could identify where he is going to, be on the hook or not on the hook, but at the end of the day, everybody agrees it's not going to make any difference. Now, does he still get to participate because his assets are going to be used in some form or another?
Yes, Your Honor, and this goes, Mr. Chief Justice, this goes to, I think, the colloquy I was having with Justice Thomas about the importance of the ex-ante determination of who a party in interest is, right? It's somebody who could be directly and adversely affected. And I think
under my hypothetical, he's going, I guess my hypothetical, he's going to be adversely affected to exactly the same extent or not affected at all.
I think as long as in the course of the case that entity is directly and adversely affected, and I think one way that we know that, Mr. Chief Justice, is because if you look at 1109B, one of the entities that's expressly listed is a creditor. And we also know that different provisions of the code, it matters whether you are impaired or unimpaired, right? So in other words, you don't get a vote on a plan if your interests are not impaired.
Yeah,
but that is different than being heard.
Yeah, we also know that in these proceedings there are some creditors that are just not going to get anything because of their particular status and all that. Now, I suppose you want to say these, technically under the rule he can go in, and maybe that's a difference in this case. But is a party in interest, is that the same test for that, Article 3?
That's our position. Our position, which is the position adopted by the Third Circuit, is that the test for that is Article 3.
Well, under Article 3, if you're not going to be injured at all because the proceedings, you're not going to get any money or you're not going to have any left or whatever it is, I don't know that that would satisfy Article 3. Just because people are going to be fighting about who gets your money, but the one thing that's clear, it's not going to be you.
Well, I think, though, you don't know that. You don't know that at the outset of the proceeding, right? So a creditor does not know, a party in interest or an equity holder does not know, and even the debtor doesn't know.
Well, okay,
until
well, that
the
I think
very
is fighting my hypothetical, and maybe it's not a good hypothetical, but assume that is the fact, that they're not going to be affected one way or another. they're just so far down the line of, people who can recover, or so far down the line of people who are responsible that they're really not going to get anything else.
I do hate to fight your hypothetical, Mr. Chief Justice, but I do think such a person, I guess maybe I'm fighting it because it's hard to know. It's maybe impossible to know at the outset of any proceeding whose ox is going to be gored and how much. That is very much an open question. That is why Congress in 1109B set a big table so that all parties in interest can come and participate and be heard and work out the negotiation among the parties who have a stake, who could be directly
I guess I'm not sure, Ms. Ho, how your at the outset rule fits with your Article 3 rule. Because as you just suggested, at the outset, there's going to be a lot of things you don't know. You don't know what the plan is going to be. You don't know whether the plan is going to affect you, injure you, or not. You don't know, all the things that we think of in the standing context. Is there imminent injury? Is there some traceability? At the outset, many people won't have the answers to those questions. So I guess I can understand an at the outset rule, and I can understand an Article 3 rule, but I'm not sure I can understand both of them together.
Sure. 2 points to that, Justice Kagan. To start, we do think that party and interest is coextensive with Article 3, but you wouldn't have to agree with me on that to agree in terms of who a party and interest is under the statute. But secondly, I do think there is.
So your first answer is you're willing to give up the article.
Well, I don't think I just wanted to make clear, Your Honor, I don't think you don't have to agree with me.
Yeah, that's a fine answer.
On Article 3. We do think it is coextensive, as the Third Circuit has held for a dozen years, and I don't think there's any tension between that and ex ante. I think the way to think about it is it's basically, do you have standing, and just disaggregating that from the merits, right? What a plan will actually do, or how the proceeding will actually unfold. In the same way that this court, doesn't let the standing inquiry determine the merits, I think it operates the same way in 1109B and the party and interest discussion and analysis, is that you're looking to see could these proceedings directly and adversely affect it. I think as to traceability and redressability, I think those requirements of Article 3 will virtually always be satisfied in every case where there's a party and interest, right?
Can I break this down? There are various points at which you decide standing. One is at the beginning of the suit. And I think this is not an Article 3 court, this is an Article 2 court. And it's not even a full court, because it can't do everything an Article 3 court can do. It's closer, not quite, to an administrative proceeding. But it's an Article 2 court. And generally, a party in interest is anyone that could be affected by a plan. The plan hasn't come into effect, but you could posit 1,000 different ways that a plan could directly financially injure someone. The chief is positing a case where there's just not enough money, they're never going to reach down here. But you don't know that, because you don't know what claims are going to be disallowed, whether some priority claims are not going to be accepted. There's just that's what you're saying about the unknown.
Yes.
Now the question becomes, when you get to the point that a plan, and this is the point we're at, when we get to the point that a plan is in place, now the question is, who can object to that plan, correct? And now the question becomes, what are the reasons you can object? And you're saying, because this plan as structured not only violates the terms of our contract, it also violates the terms of the bankruptcy court. You're saying that there's a separate good faith and fair dealing and equal treatment requirement under the bankruptcy code, and that this plan violated that, correct?
Correct, Your Honor.
Now, the net neutrality test doesn't answer that second question, correct?
Correct.
because whether or not if this plan in some way has treated you differently from the debtor's other debts with no reasonable basis to do so, that could breach the bankruptcy code, good faith and fair dealing, correct?
Correct.
All right. So now, it's possible after we go through all of this that the court below will say, nope, it doesn't breach it, but you have a right to be heard on that. That's what you're saying. That's the standing, correct?
Yes, yes.
So that's the difference between you can't flip things and get to the merits in that way. You have to look at that standing issue on the basis of the moment the plan is there, I am being affected by the plan. It's possible that that effect won't rise to the level of something that I will be given something to, but I have a right for them to hear me out on this, correct?
Correct.
Can I ask you about the difference between your view and the government's view? I understood the government's view to be narrower, but that you would also be covered by it. So do you reject their sort of contract-based determination here?
No, not at all, Justice Jackson. And I don't see the government's position as a different test.
Do you agree it's narrower than yours?
I think I would agree that it's narrower.
So why is yours better?
I actually don't know that one is better or the other. I think what the government is saying is we both agree that 1109B, that the text is broad and expansive.
Right.
We both agree that we are a creditor.
Right.
And that we were entitled to be heard that
setting
way.
Aside
I think the government's position is they're focusing on anyone who holds an executory contract, and we do.
Right.
So that brings us in. So
I guess what I'm worried about a little bit is
Yes.
that if we go beyond people who hold a contract and just to anyone who's adversely affected, I guess you could imagine that a competitor in this environment would say, I'm adversely affected, by what is happening with the bankruptcy of this other business. Would we be opening the door to allowing in the kinds of entities on the basis of your broad test that you would otherwise think Congress would not have wanted to be a party in interest?
No, Your Honor. And to be clear, we are more than happy to embrace a holding of this court that we are a party in interest who can be heard on any issue because of the insurance contract that we hold. So I want to be clear on that. But I think to your point about the floodgates argument that my friends raised, I don't think so, because I think the direct and adverse test, which we believe is coextensive with Article 3, it has teeth. Again, it has been the rule in the 12th Circuit for over a dozen years, and my friends on the other side really can't point to any sort of chaos that has resulted from it. So I think our test has teeth, and I also think that Congress, again, as I started by saying, I think the breadth is a feature and not a bug here, that Congress wanted to bring stakeholders to the table, parties in interest who had a stake. And if anyone has a stake, in this Chapter 11 proceeding, it is the insurer who will be paying the vast bulk of claims against the debtors.
This doesn't hurt your argument, but isn't it true that the insurer who's responsible for the claims will always or almost always be a party in interest then in bankruptcies? Mass tort bankruptcies.
I think that's right. And when I sort of think through to myself, who else could be brought in under our test? I do think the single largest group are insurers, and who will also often come in as creditors as well as we do too.
Counsel, just on the Article 3 point, I wonder whether we need to tangle or should tangle with it. Because I think of Article 3 as the plaintiff coming to court has to establish an injury. And who the plaintiff is in a bankruptcy case, I don't know, maybe the petitioner, right? But normally we say someone objecting to relief under bond, under Clapper, doesn't have to establish Article 3 standing. And that would seem to be a closer fit to a party or in a group like yours seeking to object to a plan.
I certainly don't disagree that in the context where what you have is someone who is only objecting, right, to the relief being sought, and that is us to a T, right? We are objecting to the plan. I think there may be a different issue raised when you get to, say, appellate standing, but in terms of 1109B party and interest, we do agree that as we are opposing the relief. Yes, thank you.
Thank you, Counsel. Justice Thomas, Justice Sotomayor.
Assuming if we reach it on the government's theory or in your theory that directly and adversely means an insured because they have a contract is a party in interest.
Yes.
That should be heard. That we don't have to reach the creditor issue or the Article 3 issue.
That's correct, Your Honor.
Justice Kagan. Justice Kavanaugh. Justice Barrett.
Well, let's see. It seems to me that maybe we would have to at least say Article 3 doesn't apply because someone like the insurer is not the one invoking it. I guess I would be a little bit worried, as you say, if Congress is setting the table broadly and parties and interests cut broadly, it's speculative, right? I mean, it's pretty speculative. You might be able to articulate a way that the plan could adversely affect your interests, but it would be speculative. And so maybe we don't have to say whether Article 3 applies in Article 1 courts, but if I think you might have a problem satisfying Article 3, I think I would still have to say you have statutory standing, right?
Yes, I think I don't believe there's any dispute that we have Article 3 standing here in a court below because we weren't heard, and so we're challenging that we're not heard.
Yes.
I do think, in terms of the Article 3 issue, the Fourth Circuit did address our creditor issue in Article 3 terms, but I think what that court was really doing was it was reading any issue out of the statute. So I think from this court's perspective, I don't think there's any question about our Article 3 status. I think the question is, are we a party in interest? We say
Right.
that's directly and adversely affected. The government says it's because we have an executory contract. Either way, I think we satisfy the statutory standing, and we also satisfy Article 3.
Oh, I see what you're saying. I mean, I get what you're saying. I'm just saying if I don't want your test, if I don't want to say that the statutory standard is coextensive with Article 3,
Yes.
That's the issue that I might have. And then just very briefly, could you describe for me, for the uninsured claims, what exactly, I mean, Kaiser and the claimants are fighting pretty hard to keep the insured claimants out. So what exactly are the fraud protection measures that would apply to the uninsured claims, the ones that you want to apply to the insured claims as well?
Sure. There are essentially two, Justice Barrett. The first would require all claimants to disclose all known exposures, right, to all defendants. And the second primary requirement or measure would be a release that would allow the trust to obtain information from the other trusts on that.
Okay, thank you.
Justice Jackson? No. Thank you, Counsel.
Thank you.
Mr. Yang?
Mr. Chief Justice, and may it please the Court, both counterparties to executory contracts and creditors are parties in interest that may appear and be heard on any issue in a Chapter 11 bankruptcy case. If a party is a party in interest, they get a seat at the reorganization table. And once they're at the table, they can be heard on any issue in the case. And that status must be determined ex ante, that is, before the court considers the questions, because the right is to be heard in advance. That doesn't depend on the merits of the position, and it cannot be determined based on what a plan proposes, because a party in interest under 1121C can itself propose a plan. Moreover, the plan is never final until all appellate proceedings on the confirmation are ended, and so they can participate all the way through. The Code contemplates that every executory contract must either be assumed or rejected. Either way, and I'd like to develop that in our conversation, but either way, a counterparty is a party in interest. I'd be happy to follow up on that.
Mr. Yang, what's the difference between your view or your approach to 1109 and petitioners?
Well, I think petitioner's view, well, it appears to me that they are interpreting party and interest based on some older Interstate Commerce Act cases that borrowed some Article 3 concepts when interpreting party and interest. We just don't think that this is a term of art. It's not clear to me that they actually say that you have to have Article 3 standing to raise an objection. I think that's more based on the term, and the Article 3 ideas were incorporated by reference to the cases. So I'm not sure we disagree about Article 3. We just disagree about the interpretive method. Our interpretive method just goes to the text. The text is broad. It's not so broad as to get amici or people with very tangential views in the case. But in this case, it certainly applies expressly to creditors, and I think it applies to parties with executory contracts. Because remember, executory contracts under 365 are either going to be assumed affirmatively or rejected. And if assumed, sometimes they're assigned to somebody else. Now, if the debtor seeks to assume a contract, they have to satisfy Section 365's standards that protect the counterparty. If there's been some kind of breach, it has to be cured. Certain contracts cannot be assumed, and the counterparty can object. Among other things, the counterparty has an interest in the debtor's ability to fulfill that contract going forward, and the debtor has to move to assume a contract. It has to show that the business judgment standard has been met. A counterparty can reject. Now, if the debtor wants to reject the contract, Justice Kagan, your opinion in Mission Products Holdings addresses this, that results in a breach of contract. It results in a claim, and then the creditors claim it. And they're not in a real good position because it's usually a pre-petition claim, and you get pennies on the dollar in most contexts. Either way, assumed or rejected, they have an interest. Now, that's reflected not only—
Mr. Yang, in an old case of ours, we used the term adversely and directly affected. Do you accept that standard, or do you think we should not have a standard like that?
I'm not really sure where that standard comes from, except unless you are drawing from Article 3. We don't really object, I think, to the outcome of having some direct effect. Whether you're adversely affected, though, I think it's the wrong question. You have to have the potential to be adversely affected in the bankruptcy, because that's what the reorganization is. You bring everybody in who has a potential to be affected, and you work it out. So going back to the pre-code Bankruptcy Act.
And sorry,
Sure.
if I could just follow up. You too, and this is just like Ms. Ho said at the outset, this is, and what if you don't really know whether you have any interest in this until the middle of the thing? I mean, I can imagine many events taking place, including there's now a plan on the table, and now you look at the plan on the table and you think, oh my gosh, I could be affected. It just seems a strange thing in a bankruptcy proceeding, which is fluid and has many twists and turns, that you would say, do this at the outset, and apparently only at the outset.
Let me answer that. I think it's easiest to answer it in the context of executory contracts and creditors, right? Executory contracts, they're always going to have potentially some effect. Maybe you just, don't know what the effect is going to be. And a lot of people who could be parties in interest, just because it doesn't fit into it doesn't make rational economic sense, they don't participate, right? They just don't participate until they have a right to, but they don't until it becomes relevant. The Pre-Bankruptcy Code Act labels executory contractors as parties in interest. Why? It's because they had to get advance notice of rejection. And there's a case called King versus Barrett of the 10th Circuit, 1973. It explains that you give them notice in a hearing so they can be heard. Currently, the current code says that the counterparty can seek an order to set a period to assume or reject. That's 365D2. Other parties in interest may similarly set that same period, but they can only do so in the context of status conferences. That's 105D2A. All of this is showing that parties in interest, that executory contract counterparties are parties in interest. Now, there's a few things that I'd like to address. One is there's a question about having a voice and not a vote. I think that goes to the question of being impaired. Impaired is what the plan under Section 1124 proposes. But there are other requirements for a plan. For instance, a plan needs to be feasible. So if you're a creditor and the plan proposes satisfying everything, but it satisfies it in a way that's not likely to end up being implemented, you can object under 1129A, I think it's A11, that the plan's not feasible. So the impairment just talks about the separate requirement that the classes vote. It doesn't address your right to be heard, which, by the way, is not only a right to be heard to object, but it's a right to be heard to support the plan, right? If you're not impaired, you may well want to come in and support the plan. The floodgates question, it largely turns, I think, on the question of any issue, not the problem of party and interest. Like, take, for instance, the vending contractor that everyone's talking about. The problem is not that a vending contractor gets to come in and be a party in interest and participate with respect to the vending contract, whether it's assumed or rejected or interpreted in a way it doesn't like. The concern is that it's also heard on any issue. But the text of 1109B and its history, the evolution of expanding those groups that can speak on any issue, foreclose any real textual ability to say, oh, you can only participate on certain issues. Any issue means what it says. Secondly, the concerns about floodgates, I think, are totally overstated. Litigants make rational economic choices where they have a stake in reasonable arguments. The right to be heard doesn't impose on the court any burden to speak at length if it doesn't think there's much to say about the issue. And the court has to decide the question anyway in terms of confirmation, because this court in United Student Aid Funds determined that the court has to decide whether the plan complies with the code even if no one objects. And finally, sanctions deters any kind of bad faith conduct. Ultimately, this is a balancing question. Does it make sense to bring everybody in? We're going to weigh it against maybe some burden of having their voices heard. We're going to balance it against the waste of resources of trying to decide who gets to be heard. And Congress struck that choice.
Is your position just boiled down to the common sense point that an insurer is on the hook for the claims in a mass tort bankruptcy as
I think that's a subset of our point. Our primary point is...
all we need is that subset. I mean, isn't that just kind of common? I just thought that
I agree, but I actually don't think it's that much different than saying that a counterparty to an executory contract is always going to have an interest. I just don't think that that's different. And the idea was that Congress, the legislative history reflects the idea here is to hear all sides of an issue and then let the court decide.
And the insurer's kind of obvious, right? That's your point.
Obvious one. I mean, but it would have included even the vending contractor. Now, the vending contractor might not have participated. Why? Because, you know what, it didn't matter. It's like small steaks, potatoes. The vending contractor is just not going to participate. There's a lot of people in the periphery that just don't participate. The 10-cent creditor, unimpaired, unsecured 10-cent creditor is expressly a party in interest, right?
What about an employee? You know, if we're going with your definition, which has to do with contracts,
yep.
I suppose an employee has a contract, so are you saying that they would be a party in interest?
An employee can be a party in interest as a party to an executory contract. Now, there are certain code provisions that deal with employees and unions and things like that, but as a general matter, yes, that's true.
And just in response to Justice Kagan, I guess I didn't understand you to be making a statement that the parties couldn't be recognized on a rolling basis, right? Like if someone determines or decides in the middle of it that they have an interest, they can ask to come in.
Yes, but yes, I think that's true. The reality is they've always had the interest to be potentially affected. They might not have realized it until later, but when they realize it, they come in and, you know, they're given a right to be heard.
Thank you, counsel. Justice Thomas? Justice Sotomayor?
In your brief, you say this case presents no occasion for the court to determine the phrase's outermost party and interest, outermost boundaries. And you repeat that today, that we should just say clearly insureds or people with executory contracts, et cetera. But don't we have to say a little bit more? Don't we have to say something like directly and adversely affected to quantify?
I'm not
to take away the employee who doesn't have a contract with the debtor, but the employee who has a contract with the petitioner truck. Could he sue and say my salaries and benefits are going to go down because this doesn't have an anti-fraud provision and the company's going to lose more money?
Well,
so I'm going to make less.
The court might well want to say more, But the court certainly doesn't have to resolve the issue with respect to whether truck is a party in interest. Now, if the court were wanting to explore the text of party in interest more, I think what I would suggest is that the court can explain that a party is a participant on one of the sides of an action or affair. It's not a person in interest, it's a party in interest. And context matters here. Bankruptcies are aggregations of individual controversies, and the participants there have an interest in the proceedings exercise of jurisdiction over the debtor's property in the distribution. If the proceeding has a potential to affect their interests, and it's not necessarily an interest in the entitlement to specific debtor property, but if the proceeding has the potential to affect their interests, that is enough to be a party in interest. Now, things that I think you're talking about, kind of 2 orders of steps out, have never been thought to be people who could come in with an interest.
I love asking this question. How do I write this so that there's a difference between that employee and the truck company? I can write it to say the truck company because it's affected, but I have to say something more to take care of those 2 and 3
The employee of truck.
Yeah.
Well, certainly the court would have to decide how far it wants to go. I don't think you have to decide employees of truck, since the question before the court is not employees of truck. But if you wanted to, we don't object to the idea that the participants that have an interest in the proceeding have always been those that have a direct kind of not attenuated effect. It's not amici, it's not some law professor, it's not employees of somebody else, it's someone with a more direct effect. I don't think that derives from Article 3, but I think you can derive it from kind of looking more generally at bankruptcy practice.
Mrs. Katie? Ms. Kim? Mrs. Barrett? Okay. Thank you, counsel. Mr. Marshall?
Mr. Chief Justice, and may it please the court. A party in interest is someone who has a legal interest in a debtor's bankruptcy estate, its property, not someone who is merely concerned about the debtor's bankruptcy more generally. The list of parties in interest in Section 1109B shows this. Settled usage of the term in bankruptcy confirms it, and the government, at least in its brief, agrees with it. At the outset of the case, the parties in interest will ordinarily be the debtor with its creditors and shareholders, those whom Section 1109B lists. Others, as Justice Thomas was asking about, may come to have an interest in the estate and thus can show that the bankruptcy will directly affect their rights or obligations. For example, if a plan would breach an insurer's policy, altering its contract rights or obligations, then it would become a party in interest. But if a plan preserves the insurer's status quo, it is insurance neutral. In that case, the insurer is not a party in interest and it has no right to object to plan confirmation. Here, the plan does not alter Truck's contract rights or obligation. It breaches nothing. It does not do anything to put Truck on the hook. That is what the lower courts uniformly found, and Truck here does not challenge that finding. Truck therefore has no right to challenge plan confirmation. Truck invokes policy concerns that would supplant this settled, clear rule with a novel, expansive framework that would give insurers greater rights to challenge plan confirmation than even a creditor has. But bankruptcy law already addresses these concerns by allowing interested entities that are not parties in interest to pursue permissive intervention. Truck simply ignores that tool. I welcome the court's questions.
Mr. Marshall, at the beginning, at the outset of these proceedings, bankruptcy proceedings, Truck was a creditor, and Truck certainly, from its vantage point, was a party in interest because of the being the one insurer for all of the claims, many of the claims here. So do you think we should look at the filing period as the point to determine party of interest, or should we do it at a later point? It would seem that you can't do insurance neutrality at the beginning. I don't know how you would do that.
If one is in the list of entities in Section 1109B, it's possible to answer that question at the outset.
So they'd be a creditor?
They were a creditor, yes. But as to their status as an insurer, the question is, do they have an interest in the debtor's bankruptcy estate? And at the outset of the case, it was obviously a no. But then when a plan is submitted and they want to claim that that would breach their policy rights and give them interest in the estate, then that would be the point at which the threshold question would need to be decided.
Let's go back a second. As a creditor at the beginning, if they are considered a party in interest, can they raise any issue in the proceedings?
Under 1109B, they generally can. In the context of a plan confirmation, if they're unimpaired, they don't have the right to object.
Isn't it just common sense that an insurer at the outset is going to have an interest in this, because how much the insurer will have to pay will be affected by how the plan is structured?
Justice Kavanaugh, they could be interested in the general sense of being concerned, which was the phrase Trump tended to use.
Not just concerned, but how much they owe, how much they're going to have to pay. It's not just I'm concerned about things, how much I'm going to.
And so then the question is, at what point do they come to have an interest in the estate? And if a plan is proposed that in their view would breach their policy, they certainly have the right to be heard on whether it would in fact breach their policy rights, and they were here. And the courts, all three lower courts held their policy rights were not breached. And so there's nothing about the bankruptcy case that puts the insurer on the hook. That can happen in cases. It happened in the Ninth Circuit case that's in the briefs. And if the plan actually...
You're saying put them on the hook, but for how much they're going to be on the hook, that will be affected, right?
I'm not sure I followed that. Nothing about the bankruptcy case changes Truck's position. If the bankruptcy case were to change an insurer's position, it would be a party in interest and have a right to object to the plan.
But they want the fraud prevention provisions. What's your response to that, as their interest in having those established?
There's a threshold question whether they are a party in interest or not, and that depends on whether they have an interest in the bankruptcy estate. If they are a party in interest, then they would have the right to come in and raise the issues of concern, including the fraud prevention measures. But it's a threshold question. Perhaps it's helpful to think of an analogy. A creditor, as we were discussing with Justice Thomas, has a right to raise any issue under 1109B. But there's a threshold question whether you actually are a creditor. So you can come in and you can say you're a creditor. You don't actually have to move to intervene. And if somebody challenges that, then the court has to decide, are you a creditor or not?
Why are you fighting this so hard? Why do you want Truck to not even be heard? Just what is your motivation to be fighting this so hard? We
have a deal with the creditors. We think it's a valid deal and a good deal, and we want to be done with bankruptcy. And we don't. Truck is coming in to try to blow up the deal that we have.
Can I stop you a moment? I am looking at the brief of Amici American Prosperity Casualty Insurance. And on page 15, they explain that once the plan is approved, this plan, under your terms, it obtains a discharge, the debtor, and the protection of a channeling injunction. Now all the claims are going to go through the trust and not to you. The debtor has no ongoing incentive, after the plan is approved, to limit the cost of defending, paying claims, and any liability on those claims. You lose it. That's the benefit bankruptcy gives given you. And the claimants, their incentive for this plan is that they don't want the anti-fraud provisions. So who's protecting the insured? If the insured can't protect itself because you say it can't go to the bankruptcy court, how is it being heard? Because what you're suggesting to us is that they don't have a right to say the plan is violating a bunch of other provisions of the code, 1129A, or permitting the differential treatment of people who are owed money or of claimants? I mean, I just don't understand your argument. I can argue that the plan is breached, and once they say the plan's not breached, I can't argue that the plan violates the code? I've just never heard of parsing standing in that way.
Justice Sotomayor, if one is not a party in interest, there's no right to raise issues. Party in interest status is a threshold question. And here, as to Truck as an insurer, they need to show they have an interest in the bankruptcy estate to get in, to answer the threshold question.
But they do.
But I guess the question, Mr. Marshall, is, I think what everybody's saying to you is, well, they do have an interest in these anti-fraud provisions. Not just a concern, they have an interest, a material interest. If they get the anti-fraud provisions, they're better off. If they don't get the anti-fraud provisions, they're worse off. Now, what I hear you saying back is they had no pre-existing entitlement to the anti-fraud provisions, and your test is one that says if they're not being made worse off by the plan, then they're not an interested party. But I don't know why that should be the test. If I look at the language, that's not the test. If I think about what the ordinary meaning of being a party who's interested is, that's not the test. Why is your test, so long as they're not being made worse off, they're not an interested party?
Well, the test of whether there is a benefit I would like to get out of the bankruptcy case, which is Truck's test, is unlimited. Anytime you could imagine a hypothetical plan that would be better off for you.
That's a practical concern, and I think, the practical argument against it is it's pretty costly to enter into these proceedings, and nobody really does it unless they have a serious interest. And anyway, bankruptcy courts have docket management techniques. And anyway, just putting aside the practical concerns, is this a floodgates problem or is it not a floodgates problem? I don't really see why your test, which is are you being made worse off or are you being made, or is it, are you just being held to the bargain that you initially had? I don't see why anybody would think that that's the way to answer a question of whether you're interested in a proceeding.
Party in interest is a term of art that means you have an interest in the debtor's bankruptcy estate. That's been the meaning for 100 years. And so that's the way to start. But if we're going to think in terms of seeking to obtain a benefit in the context of causes of action, Lexmark, zone of interest, the question is always, have you suffered a loss? If you've suffered a loss, you come in and you try to get a remedy. What Truck is saying here is I can come in, even though I'm suffering no loss at all to my legal rights, and just seek to obtain a benefit because it's very nice that this bankruptcy is here and maybe I can get something out of it. But even if they don't have the right to come in, there's always permissive intervention. So there's the right to come in as an interested entity that's not a party in interest. The benefit of that is it's in the discretion of the bankruptcy court. You have to show cause. The bankruptcy court can decide whether you come in for all issues or just some. The question is who has the right to intervene in the case.
Would you object to permissive intervention in a situation like this, where the insurer's seeking fraud prevention?
We would have objected to their attempt to come in and object to the merits of the plan, but they certainly have the right. Yeah.
The question was
they could have sought to pursue permissive intervention under 2018 to get to the merits of the plan.
Would you have objected to that?
We probably would have opposed that.
Why?
For all the reasons that we're otherwise opposing.
You just don't want them to be heard.
They have the right to be heard.
You don't want the fraud prevention provisions, but you don't want them to be heard on that. Is that, that's okay.
Well, all the lower courts, they were heard on that. All the lower courts ruled against them on the merits as well, but the bankruptcy and the district court, although the Fourth Circuit didn't get to it. It's good to keep in mind, if we're going to be talking about the policy concerns, that bankruptcy is just not about get everybody to the table. It's also about having an efficient and expeditious proceeding that makes it possible to resolve what is ultimately a question about the debtor and its creditors, or in some cases, its shareholders.
Well, it may not be about getting everybody at the table, but you do want all the creditors there, don't you?
Yes, you do want all the creditors there.
Well, they're a creditor.
As to the plan that's at issue here, they were an unimpaired creditor, and an unimpaired creditor does not have the right to object to a plan. That's Section 1126F.
But at the time,
Mr. Marshall, the language, you agree that they had an interest in the plan finding, right? About the good faith and about whether this was going to be collusive. everybody said below that they had an interest in
The plan finding was a threshold question that they certainly had the right to litigate.
Right. And they did have an interest as a creditor because of the deductibles that were due, right?
They were a creditor. As to the plan at issue here, they were unimpaired and didn't have the right
but that's looking ahead to the plan. I guess what I want to say is that 1109B says that a party in interest, including our list, may be heard on any issue in a case under this chapter. So if they can be heard on the plan finding, or if they're a creditor, I guess I don't understand why on the text of that provision they can be so limited and say, well, you can't bring up anything else, even though the text says any issue. It doesn't limit it in that way.
I'll address that in two respects. So the plan finding, again, is the question of whether they are a party in interest in the first place. It's a threshold question. It's like deciding jurisdiction or statutory standing. You have to get through that to get to the merits. So as an insurer, nothing about the plan finding changes whether or not Truck is a party in interest. They're not. As to a creditor, we're talking about the right to object to a particular plan that leaves them unimpaired. And although 1109B has that general language, 1126F more specifically says that an unimpaired creditor is conclusively presumed to have
maybe I'm not
accepted.
understanding about the plan finding. I mean, it's true that at the end the court said that Truck wasn't harmed, but what if the court had decided otherwise? In the beginning, they don't know whether it's going to be collusive or violate Kaiser's duty of good faith, right? Maybe I'm just misunderstanding. I mean, it went in your favor, but...
Party in interest status is a threshold question. You have the right to come in and litigate whether you're a party in interest or not. And that's all the plan finding did. It determined that their rights were not abridged, and therefore they were not a party in interest. If that had gone differently, then yes, they could have objected to the rest of the plan to the merits.
Mr. Marshall, you've agreed that they were a party in interest to the extent they were a creditor, right?
Yes.
And normally a creditor or party of interest can be heard on any issue. You agree with that?
That's the text of 1109B.
Okay. And you've been citing 1124 and 1126 to us. I understand and appreciate that, but that governs who can vote, right?
That is what it explicitly says, yes.
It doesn't talk about what they can argue about or be heard on, right?
It says they're conclusively presumed to have accepted the plan, right. And an inference from that is that it would be absurd to vote
So if you can't vote, you can't be heard. Is that your argument then?
You can't be heard on the merits of the plan. And that's what the circuit courts have said. We cited cases, and Truck cited some cases allegedly to the contrary, but they're actually not, because all they do is determine whether the creditor that wants to object to the merits of the plan is actually impaired.
Thank you, counsel. Justice Thomas? Justice Sotomayor? Justice Gorsuch? Justice Jackson?
Can I just ask one question? At the threshold, you keep saying at the threshold, they have no interest in the estate property. Do you dispute that they have a potential to have an interest in the estate property, that insurers do? Because the plan isn't in existence yet. Do you dispute that they have the potential?
Borrowing from intervention law, the question would be, when is their interest put at issue? And it's somewhat like which would be, is a plan proposed that would breach your contract and give you an interest in the estate? And it's analogous to what the actual history is with executory contracts. So the statutory history that the government invokes actually suggests your party in interest when there's a motion to reject an executory contract, because that would create a claim, a breach, and make you a creditor.
I guess I don't understand your answer.
So, when it's put at issue?
When it is put, why isn't it put?
If you're an insurer, you're not in the list. Nothing makes
right,
your
but
party
the list says including, so we know there are things that there are entities that may not be in the list, right?
Correct.
Okay, so the question is, they come to the table at the beginning and they say, we think we should be in the list because we have a potential through the reorganization plan that will be adopted to be affected. And you say not party in interest because you're not already affected, or it's not clear to us right now that you're affected. Is that your position?
If we're talking about Truck as insurer?
Yes.
Yes.
All right.
But once a plan is proposed that would breach your contract?
So can I ask you, if people who are not potentially affected are not parties in interest, I guess I don't understand Congress's suggestion that parties in interest should be a part of the reorganization. In other words, the context in which what's valuable to them about being a party in interest is the fact that they then get to talk with everybody about how this is going to go. And the problem I'm having with your argument is it suggests that it's only after we know or after they know that they're definitely affected that they get a seat at the table. But the whole point of it is that the parties in interest get to talk about it. So it seems to me it would have to include people who have a clear potential for being affected by the plan that we're all hammering out in this discussion.
There's nothing in 1109B itself that says that has to be determined for once and for all at the outset. And if we're talking about someone who's not in the list, the only way to know if you're a party in interest is do you have an interest in the bankruptcy estate.
Thank you.
Thank you, counsel. Mr. Frederick.
Thank you, Mr. Chief Justice, and may it please the Court. There are a number of questions I'd like to address that you posed this morning, but I want to start with one principle, which is that the Bankruptcy Code was not intended to protect insurers except in a couple of places where asbestos-related trusts are created. Those are in Sections 524G principally. But in 109, Congress said an insurer can't invoke bankruptcy for protections under the code. So, Justice Kavanaugh, to your question about the text and practicalities, Congress answered the question of whether an insurer should be permitted to butt into a debtor's bankruptcy and try to use it to protect its own financial interests. The bankruptcy process is designed to ensure that the debtor can maximize its assets for the benefit of creditors. And so what the insurer, as insurer, is doing here is seeking to co-opt the debtor's bankruptcy for the purpose of protecting its own interests. Justice Thomas, I can start with the timing question if you like.
Well, you can start with that, but also I think that their interest isn't so much in feathering their own nests per se, but rather that they be treated with the anti-fraud provisions the same way that the claims under the trust are being treated.
Yes, and let me start with I'm going to call these pretrial disclosure requirements because Truck had 6 months of discovery to try to prove any fraud with the Kaiser claimants and came up with crickets. What they are calling anti-fraud prevention measures are really requirements to impose on state courts that before a claimant can file a claimant has to comply with what Truck wants for information that a state court might or might not require under state court rules of procedure. So if you were to accept the idea that their nomenclature drives the outcome here, you're essentially saying bankruptcy courts have the authority to tell state courts how to do their discovery process. And Justice Barrett, that's why we're fighting this. Because the claimants shouldn't be required to impose on themselves and their families a lot of information that if Truck really wanted it, he could ask for it in state court discovery proceedings, and state court judges could decide is that relevant or burdensome or not.
Why do all these other circuits and other bankruptcy courts impose it? If they felt the same way that you're arguing, are they violating the bankruptcy code or disrespecting state courts because that's what they require?
No. The requirements here are only for a very small class of claims that are called extraordinary claims. And they are extraordinary claims, and it's defined at JA 427 under the plan. These are not insured claims where the claimant is seeking to say that Kaiser was responsible for the vast bulk of its exposure to asbestos. And in that very unusual circumstance, which actually in the implementation of this plan hasn't arisen yet, the requirement is for that claimant to come forward with proof of a negative, that it hadn't been exposed to asbestos by any other potential tortfeasor. And so we're talking about a very narrow class with a description for a very particularized purpose that Truck wants to appropriate enforce so that claimants will have less of an opportunity to invoke their jury trial rights in state court, which are protected under the U.S. Code.
Why should you, as the debtor trust, have that advantage and not give it to them?
Because
that's the difference in treatment that they're claiming is contrary to the plan.
It's not, for this reason. The treatment by Kaiser of Truck is exactly the same before bankruptcy as it was now. Truck agreed
But bankruptcy
contractually.
changes everyone. It changes who the debtor is to the trust. By its own terms, it's extinguishing the debtor's obligations to anyone, except under the extant contract. But the incentives are different. There's inherent change.
That's why the principle of insurance neutrality, which was developed 30 years ago in the courts of appeals and has actually followed in every single court of appeals that has addressed this question, has looked at whether the insurer's legal obligations are altered, and if they are not.
Then circle back to my initial question. Other bankruptcy courts have imposed these same requirements, and they've done it. Are they breaching bankruptcy law? Are they stepping on state courts in an improper way? What are they doing? And why are you fighting something that you admit your claimants in discovery might well have to give up?
Because it's up to the state court to decide that.
Why?
Because they're the ones that will be superintending discovery.
But what does that have to do with
because
the cost? What does that have to do with anything? Meaning, if you eventually, in most jurisdictions, will have to give up something like that, because there is very few jurisdictions who would say they have to pay the entire cost if there's multiple exposures, or they have to pay the entire cost if other people have paid you. That's all that's being sought.
It's more than that, Justice Sotomayor, which is why they're fighting so hard for it. And I want to make this very clear, that the point of the extraordinary procedure is because the trust itself is having to pay the claims. They are not insured by definition. And
that's the whole point. You're trying to give yourself something more than you're giving someone else, and you want to reach into their pocket and say, I'll give myself more than you.
Because the contract of insurance, which they litigated for 19 years in California state courts, definitively determined they will have to pay the claimants who are insured.
So I think I'm getting the equities of this, Mr. Frederick, as you describe it, is that they had a contract and they've been protected as to that contract, and they're just looking to get a better deal now and to kind of take advantage of the bankruptcy. So I'm getting the equities here. I'm not getting where you derive from the text the idea that they're not parties in interest because they have a material interest in what comes out of the bankruptcy proceeding, and they can improve their position materially in the bankruptcy proceeding.
The cases that we cite historically under the Transportation Act of 1920 make very clear that if you're just seeking a benefit, you don't get party in interest status. You have to show aggrievement and harm to your position.
So those are some 1920s cases. Do you have anything in the text that can suggest that the text has incorporated that view?
We don't have anything like that, although I would point to the history that the debtor's brief very helpfully lays out, which explains how the origination of the bankruptcy code went through these iterations and accepted those principles for party and interest. And I think that it makes sense from an Article 3 perspective, too, because the other side is essentially saying Article 3 has no role to play here, where a bankruptcy process is a multifaceted fight over a res. What is the debtor's estate? Who gets that property? And so those claims are going to be somewhat flowing in and out. And it is imperative in the 524G context that you recognize Article 3 has a role to play. Why? Because the district court has to enter the final injunction. The bankruptcy court does not have the authority to do that under the statute.
Mr. Frederick, I certainly get your arguments and why they might persuade a bankruptcy court to rule for you and not require these anti-fraud provisions. But I think you've admitted that a court can do those provisions, and they have done them in other cases lawfully, right?
For the trust's benefit, but not where there's an insurance neutrality clause.
So the question becomes, can they be heard? That's the only question before us. Can they be heard at all? And I guess I'm struggling on that one. We're not discussing the power of the court. We're not discussing what it might rule. We're only discussing who can be heard. And I think you have to acknowledge that there are creditors who can be heard, even if it's a virtual certainty that they will get nothing, or a virtual certainty they will get 100 cents on the dollar.
Right.
They still can be heard.
They can be heard until the point where their impairment is determined.
Well, they may not have a vote, but they can be heard on any issue. No?
Until their impairment has been determined, Justice Gorsuch. That's the key point.
Where do you get that from?
1126F.
That's who votes.
But the point of voting is who can hear, and the whole point of the chart, which you can see the bankruptcy court's determination, is who's impaired or not, because the bankruptcy court has to get to an end place. There were a dozen insurers here, and under their position, there is no limiting principle to any of those insurers who could continue to fight because they want to get benefits out of a bankruptcy process that Congress foreclosed.
Do you agree on Article 3 that's with respect to a plaintiff coming to court and not with respect to those who object under bond?
No,
Clapper?
I don't agree with that.
You disagree with Bond and Clapper on that?
I think Clapper is actually more helpful for our side.
What about Bond?
Justice Bond, I think that the point is where the effort by the objector in this situation is seeking to get a benefit and must show under Article 3 that it has injury in fact that is redressable and traceable to the plan. Here, Truck can't satisfy either because its redressability problem is really because they think state courts are not going to be adequate to police fraud, and they are not able to trace their harm as insurer to the plan because of the insurance neutrality provision. And so I think there's a very serious Article 3 question here that Truck has essentially glided by in this argument this morning, but I want to urge you to take that very seriously because it can't be the case that we have like a law school seminar, anybody who wants to come and talk gets to talk. The whole point of a bankruptcy proceeding is get to a confirmed plan. And the only way to do that is to weed out the people who have something that they want to say and to have different threshold provisions. So, Justice Thomas, I wanted to get back to your timing question. At the disclosure statement, the debtor has to present a plan that is where the issues of insurance neutrality typically are going to be addressed. And at confirmation, we are knowing then that the creditor is impaired or not impaired. So those are the two key timing mechanisms. It can't be at the outset of a bankruptcy because there isn't enough known about the nature of the estate.
Well, if he's not impaired, doesn't he have an interest in making sure that doesn't change?
He does, but that's where the confirmation of the plan comes in. And that's why if you look at the chart, Mr. Chief Justice, this group is unimpaired, this group is unimpaired because they are paid in full. And Truck was paid in full for its premiums. So it is not an executory contract, which under the Vern Countryman definition was where there was lack of performance on both sides of the contract. Here the debtor performed on the contract. The debtor paid all the premiums. And so it is a non-executory contract, which I think helps give the lie to the government's position that calling something an executory contract is somehow going to solve the problem here, where you've got performance that is occurring at different levels and at different stages. And that's why the DOJ policy manual itself says be very careful about invoking executory contracts because they are not defined in the bankruptcy code, and it's very difficult to know how to administer them in practice. And so for the government to be suggesting that you have a test here that is so malleable, where the interests of claimants and creditors is critically important to understanding how to weed out the various muckrakers where and I would point you to the policy holder's brief, pages 12 to 14, which talks about just how long the insurers have an interest. Why? Delay is profit maximizing. Every day insurers do not have to pay on their claims is a good day for the insurers. And so they have every incentive to tell their lawyers, go in and object to everything because that will delay the process. We could have had this plan confirmed 5 years ago. The only objector was Truck. Every other insurance company agreed to the plan. And so by adopting some rule that everybody gets to be heard and everybody gets to participate.
Is Truck on the hook for the majority of claims?
Truck and other insurers.
But isn't Truck responsible for the lion's share?
That's what they say, and I have no reason to doubt it. But Justice Barrett, where do you draw the line there? Do you say that an insurer that's responsible for 2/3 gets it? We heard that.
I was just saying that it means less that other insurers didn't object if they didn't have the same stake in the claims.
We don't know what the comparative issues are. The excess insurance part is under a confidentiality standard that I have not seen, and I can't tell you in court what that entails. But what I can say, Justice Barrett, is that it can't be a size issue, because there's no way to draw a line on a size issue. Where do you say it's a quarter is enough, or 6 insurance companies that each have an equal stake is enough? How do you?
Can I ask you a timing question? Can you be a party in interest? I'm just trying to understand your point about how things change as a plan's developed. Chief, do you want me
Sure.
to
No.
stop?
Go ahead.
Can you be a party in interest at the beginning and then not be a party in interest as it becomes clear your interest isn't impaired? Is that what you're saying?
I'm saying that impairment is treated differently. So you can be a creditor and a party in interest, but you are not allowed then to vote on a plan and thereby exercise your voice through your vote.
Okay.
The code treats that differently, and it's odd to suppose that an unenumerated party like an insurance company is treated better than a creditor.
Thank you, counsel. I just want to follow up. You were just making the point that you can't draw that line. I mean, the law does that all the time, right? I don't care where it is, and it may be the majority or a significant part of it or whatever.
And that's why I think looking to the guidance of the courts of appeals is actually humbling at one level, but also instructive. For 30 years, courts of appeals have looked at this idea of insurance neutrality to determine whether a plan is materially altering pre-existing legal obligations. In those cases where the court has said, yes, it is, insurance companies are allowed to be parties in interest. That's the Thorpe case out of the Ninth Circuit, the Global case out of the Third Circuit. But in those situations where there's an insurance neutrality provision and the insurance company is not able to say with any proof that its legal obligations are materially altered, the courts of appeals have said, you're not a party in interest.
Well, wouldn't Truck want to have something to say about the division that you've just cited?
And they do, Mr. Chief Justice, because that issue is litigated. When my friend was talking about this being at the threshold, the whole question is the insurance company's legal obligations, are they impaired or not? And that fight is a very vigorous fight.
But that fight continues beyond what you're calling the threshold.
It does and it is, but at a point where the plan is confirmed and we know there will be insurance neutrality and we know that their rights as a creditor are not giving them a right to vote, at that point it should stop. And the 4 years that we've spent doing appellate litigation here ought not to be necessary.
Justice Thomas? Justice Sotomayor? Justice Kagan?
Can I just ask, because you called them muckrakers, the amicus brief for the professors on the other side, and you can just respond to this, says, indeed, when an insurer faces millions of dollars in financial liability, like Petitioner does here, common sense and fundamental bankruptcy policy dictate that it be considered a party in interest in the bankruptcy proceedings. So you can just, I mean, this is repeating what you've said probably, but that sounds different from muckrakers.
Well, what I would say, Justice Kavanaugh, is that a party in interest has extraordinary rights. They have the right to contest the trustee, the appointment, the powers of the trustee. They can object to the lifting of the automatic stay. They can ask for the elimination of the plan. They can ask for the transformation of it from a Chapter 11 to a Chapter 7. And those powers and rights are very powerful, and they take bankruptcy courts an enormous amount of time to thoughtfully and conscientiously work their way through.
Thank you. Justice Barrett? No. Justice Jackson? Thank you, counsel.
Thank you.
Ms. Ho, you have rebuttal.
Thank you, Mr. Chief Justice. 3 points, 2 quick and 1 a little bit longer. 1, just to really underscore 1126F, that is about voting. That is not about what 1109B about, which is being heard. Two very different things. Number two, on intervention, Congress did away with the requirement that parties and interests must intervene when it replaced 206 and 207 with 1109B. And three, my friends have talked a lot about the insurer in this case trying to get something out of the bankruptcy or seek a benefit. Trying to stem the tide of overinflated claims is not seeking a benefit. It's just trying to make sure that the plan complies with the code, as bankruptcy judges have an independent duty to ensure. And even if you disagree with me on that, it's undisputed that Truck is going to pay the vast bulk of claims in this case, that the plan finding adjudicates Truck's insurance rights, that Truck is a creditor because the insurance deductible. So it really is a party in interest several times over. And I haven't heard from my friends on the other side any justification for reading any issues out of the text. 1109B gives stakeholders a voice, not a vote, and certainly not a veto. We would respectfully ask the court to reverse and remand.
Thank you, counsel. The case is submitted.
The Honorable Court is now adjourned until tomorrow at 10 o'clock.